notice or after notice?
My lord, this is my lord fresh matter, my lord.
So notice what? Delay is what?
Delay, my lord.
180. All right. Notice on notice returnable 24th August.
No delay. There is no delay, my lord.
The delay you say in view of the Supreme Court orders. Since delays occurred during the COVID period, it's condoned, then you say in the main writ appeal, notice returnable 24th August. Notice on IA also.
Item number 2. 2 months Sattaparda, 8th of May, my lord. Item number 3.
May I please, Your Lordship? This is a matter the petitioner has rendered 27 years of ad hoc service, and she is going to retire 2 months during June, my lord. And Your Lordship last time desired that whether there are any judgments in that regard. My lord, I have obtained 7 judgments.
Sure.
My lord. Civil appeal number 1007.
Yes. Yes, please. Sir, you'll have to proceed in the matter. What do you want to cite? Please tell us.
My lord, in our own High Court also there are 2 judgments I have submitted, my lord.
No. First, you come to first set out the facts and then you make your argument.
My lord.
You have the counter affidavit filed in the writ petition?
Yes, my lord.
Come to that counter affidavit. The counter affidavit, see para 7. You need some time or you're not ready with the matter? You need some time or you're not ready with the matter?
My lord, the petitioner had filed 3 writ petitions, my lord.
Sir, we're asking you to read the counter affidavit.
My lord.
Filed in your writ petition.
Please read the counter affidavit.
My lord, I have filed the rejoinder, but counter affidavit I have not filed.
You
I
could
may-
not have filed, sir. The state has filed. We are asking you to read
Yes, ma'am.
the affidavit filed by the state.
Yes, my lord.
Huh.
That I have not enclosed it here. Next week, my lord.
Just give this back.
It's not available in my file.
Yes, but it is not available.
For the appellant needs some more time to prepare his arguments. Yes, sir. 23rd August.
Item number 4.
Then appeals dismissed.
Item number 5.
May I please, your lordship? The matter relates to eviction of the petitioner on the ground of encroachment, my lord. The counter is not yet filed, my lord. The petitioner in possession of the land more than 40 years rehabilitated by the government. Counter is required in this case. Last occasion, your lordship directed to counter the file.
How is this a PIL? I don't understand.
It is
No,
not.
no.
It is not.
Counter is required in this.
No, is this a PIL?
No, my lord. It was the order of the collector on the basis of which, on the basis of the PI filed by.
Why is it come before this bench?
That it's not, that is also
Your
it's a
lordship has.
single bench matter, single bench matter.
Right. It's a single judge matter.
Or I have put up before the appropriate bench, my lord.
It is pointed out that the present petition is not a public interest litigation. And in fact, it is a matter for the learned single judge. This before the appropriate bench. On 3rd July.
Obligement.
Item number 6.
None appeals dismissed.
Item number 7.
May I please? Let's not turn to page 15, annexure 1. On the very first day, Honorable Singular are directed to open the GPF account, though he is a block grant employee and his post has been approved in the year 2012. Page 15. ma'am.
What is the harm in opening a GPF account?
He is a block grant employee and the GPF account in respect of that old pension.
No.
Yes, ma'am. After 1/1/2005, they are CPF, not GPF. It's a block grant.
No, is there in contempt filed or anything? This is an order of 2020, 17/11/2020.
Ma'am,
Was the contempt filed?
no contempt in my
Then-
file, ma'am. But CPF account.
Appropriate action. All it says, take appropriate action in the nature of submission of proposal.
Illustrative that considering consider to look into the request to
Look into the request. What is all
And
this? Is all innocuous, sir.
and
If
submission
you
of
think it's not, shouldn't be GPF, it should be some CPF or something, you tell them.
and before the operator for opening of GPF account, my lord.
No, appropriate action, sir, in the matter of submission of proposal. All this is
And the operator partner to look
nothing. There's no compulsion on you to open this.
And,
They're only asking you to consider this.
here, my lord, he is a employee of that higher education. The director has no jurisdiction.
Then you say that.
Then
When you say that, there's no this. Whichever is the appropriate authority, you can always send it to that appropriate authority.
so far as that part is concerned, my lord, we have to open the GPF account. So because
No. It's only to consider, take appropriate action in the matter of. That's all it
and
is.
appropriate action in the matter submission of before the operator for opening of GPF account.
Correct. So if you think it can't be GPF, it has to be something else, you make that proposal. If you think you cannot do it, some other authority, you ask that authority.
Even I am not on the authority, my lord, because that so far as GPF account is concerned, my lord, because they are not covered under GPF.
Then you say that.
That they are only
This
covered.
does not say that despite they are not being covered, you have to open. It doesn't say that. You say the direction issued by the learned single judge in the impugned order dated 17/11/2020 is innocuous inasmuch as it requires the appellant open quotation to look into the request of the petitioner and take appropriate action. ... Unquote. Full stop. The court does not find the order giving rise to any ground for interference. The appeal is accordingly dismissed.
My lord, may I submit? Your lordship, may observe my finding, my submission, my lord, that he is not entitled to be covered under GPA. Because what is happening, my lord, in these cases when we are rejecting their representation, they are coming with a contempt petition.
So you can answer that contempt accordingly. Sir.
That your lordship,
Item number 8.
That's my answer.
with that observation, my
Sir, there's no contempt file so far.
No, no,
Let's not
I-
imagine it. Yes. Right.
Item number 8. 8th of May, Sattaparda case. Item number 9. 9 Pattapavan Biswal case. Your lordship is granting liberty to us to file review. Similar matters lordship are disposed of.
Counsel to the appellate seeks leave to withdraw the present appeal with liberty to file a review petition in accordance with law. Disposed of is withdrawn with liberty is paid for.
Item number 10.
Then there is a delay of 1,056 days, Your Lordship.
yes, my lord. There is a delay of 500 odd days. Admitted
Without COVID, it's 674.
that I am saying that 500.
So otherwise what is the matter about?
The matter relates to my lord that the area payment of he's claiming area payment from 1994. He approached this honorable court in 2014 that we are relying the judgment of Darshan Singh that at best he can claim from the date 3 years from the date of filing of that petition.
If you agree, then we can confine it.
Your Lordship, kindly see the date chart.
That is the only short point here, my lord.
Your Lordship, may kindly see page 35. Page 35 is the writ application filed by me, wherein basing on Abhavananda, this honorable court disposed of for disposal of the representation.
Assuming for the sake of argument,
Your Lordship,
your lordship
only-
taken into account, your lordship may see page 35, the date of order and the date of
Yes. In respect of
2000
in respect of
2013 is the writ petition. If 2013 will be taken into account, then he is entitled from 2010.
No, but that argument you must have made in 2018 when he again filed a writ petition.
Yes, he again filed another writ.
But the court did not agree.
Yes, in
that
page
clarification.
30 in page 35, your lordship may see there was no direction to consider his your lordship may
We'll dismiss
page
it on
35.
delay, sir. We'll dismiss it on delay. You say there is a, despite accounting for the, you say there is a total delay of 1,028 days in filing the present appeal. Even accounting for the COVID period, the delay is 666 days. Full stop. The explanation offered in the application for the inordinate delay of 666 days is totally inadequate. And going by the law explained by the Supreme Court of India in Living Media India Limited, and the Berulal versus State of MP versus Berulal, the above explanation cannot be accepted to condone such an extraordinary delay. Stop. Accordingly, the delay is not condoned. IA so and so is dismissed. Consequently, the writ appeal is dismissed.
Two contempt application has been disposed of, but till date the order has not been complied solely on the ground that writ appeal is pending, Your Lordship.
Now you'll know, sir. It's okay.
Item number 11. Item 11.
9, 10.
None appeal is dismissed.
Item number 12.
Item 12, my innocuous prayer is that as per order of the Honorable Single Judge, I will file a representation before sole opposite party and
Then you are accepting the you say,
accepting my
counsel for the appellant states that in terms of the impugned order of the learned single judge, he will make a representation before the concerned authority not later than 1st June 2023. If such a representation is made, then it should be disposed of by a reasoned order within a further period of 12 weeks and be communicated within 7 days to the appellate. No further directions are called for. The appeal is disposed.
Item number 13.
Item 13, 14, 15, tomorrow.
Tomorrow. All right.
Item number 16.
Item 16 my sarta padam.
All
8th
right.
May.
Item number 17.
Sarta pada 8th May.
Item number 18.
None appeal is dismissed.
Item number 19.
19 my sarta pada 8th May.
Item number 20.
None appeal is dismissed.
Item 21.
Same order.
No, item 21 can pass over.
All right. Pass over.
Item number 22.
So item 22, my lord, I was appearing for the respondent in the writ petition, my lord.
Hmm.
Here, the order of the honorable single judge
Yes, sir.
has been complied with 2 years back.
Oh,
Now the my lord,
I'm for the petitioner, your lordship. Already complied with the single.
All right.
may I just
all right.
pass on the order.
All right. The court is informed that the impugned order of the single judge was complied with more than 2 years ago. That view of the matter, the
18.
present appeal has been rendered infructuous and is disposed of.
Much obligement.
Obliged, your lordship.
Item number 23.
Tomorrow,
Sarta pada.
Sarita Parada.
8th. 24, 25 also same.
All right.
Item 26.
None appeal is dismissed.
Item number 27.
27. Mr. Lenka is not well, so
Counsel for the appellant is unwell. When are the other matters kept?
my lord.
Yesterday we adjourned yesterday some matters. Yesterday in a similar matter we adjourned to a certain date. You don't remember?
Item 20.
You only appeared, sir.
My lord.
Single matter, similar matter. 27. Dita file is करचो. Editor मैंने same लोग करो dita file करचो.
All right. Just sit.
ये दयानंद file में जो
28th August. All right.
Obliged. Item 28.
That is RSCP matter. The lordship has issued notice in a similar case yesterday in W number 65 of 2022, item number 69 in its yesterday's list.
What date?
WS 65 of
No, what
2002. Date not uploaded.
28th August. Notice returnable 28th. List
WS
along with WA number
65 of 2022.
65 2022. All right.
Item number 29.
29 months of the party.
All right.
8. Item number 30.
30, my lord, challenging the order of the learned single judge, my lord. Here, the petitioner, the respondent was working as an assistant professor in the district of Baripada, my lord. In 2019, she joined the post. In 2020, there was an advertisement made by AIMS Bhubaneswar, wherein applicants were directed to apply for the post of assistant professor. She had applied for the post of assistant professor. She came out successful. There was a clause in that agreement on the advertisement, my lord, that she needs to produce the NOC from the employer. We as an employer, we rejected that grant of NOC, my lord. The ground we have rejected is that, my lord, there's dearth of, my lord, assistant professor in government medical colleges, my lord. And new medical colleges are coming up for which these professors are required for to meet the exigencies, my lord.
No, you can't just stop somebody like this, sir. The grievance of the respondent in writ petition civil 4242 of 2021, which has been allowed with the impugned order dated 12/2/2021 of the single judge, is that the present appellant is not issuing a no objection certificate, bracket NOC, to enable her to appear in the interview for the post of assistant professor in AIIMS Bhubaneswar. Paragraph. Having heard learned counsel for the, it is noted that the respondent belonged to the ST category and was working as assistant professor in the Pandit Raghunath Murmu Medical College and Hospital, Baripada. And while so working, applied for the post of assistant professor in the ST category in AIIMS Bhubaneswar. Stop. The observation of the learned single judge that being a model employer, the state government should not stand in the way of a prospective candidate like the appellant, who is looking at growth prospects from appearing in an interview appears to be fully justified. Full stop. Indeed, it is unreasonable for the appellant to create hurdles for the respondent to appear in an interview pursuant to the advertisement for recruitment of the post of assistant professor in AIIMS Bhubaneswar. Paragraph. The court is unable to find any grounds made out for interference with the impunity of the learned single judge. The appeal is dismissed.
Item 31. 31, 32, 33, 34, my lord, 25th of September, Lordship, get yesterday the match of matters.
All right.
DLR declaration.
All right. These are fresh matters or old matters?
My lord, fresh matters.
Fresh matters?
Yes, sir.
Oh, so notice returnable 25th September. List along with?
My lord, the batch of matter was there yesterday, my lord.
No.
The reading case.
137 of 2022.
137 of 22.
2022.
2022. All right.
Item number 35, 35, 36, 37, and 38. Sartapada 8th May.
8 May.
Item number 39.
May. I am for the appellant, my lord. The case of the appellant is that, my lord, though the opposite party number 4 has secured less mark than the appellant, he has got appointment under SCBC Home Guard category as constable in Orissa Security Industrial Force, my lord. But I have not given appointment. I challenge that order inaction of the authority before the tribunal. Thereafter, this honorable court has passed an order. Kindly see page 94, my lord.
Oh, it's been remitted to the authority.
Remitted to my sole limited grievance is that, my lord. As per this order of the honorable single judge, I got appointment. The appointment order issued in the favor of the appellant on 12/10/2022. My sole grievance before your lordship in this writ of plea is that the appointment should have given from the date when the less meritorious candidate have appointment, my lord. Only to that effect I have prayed here before lordship.
No.
So kindly see the honorable.
It appears that
my lord, kindly see, I have secured 41 marks. The candidate, those who have secured 28 marks, they have got appointment, my lord. But I didn't got give appointment by the authority. Thereafter, I challenge that. My date of appointment should be antedated notionally from the date when my less meritorious candidates have got appointment. But the honorable single judge has directed to consider fresh, my lord. Even there is a vacancy, my lord. My case, there are some less meritorious candidates have got appointment, but I could not get appointment. Thereafter, I challenge, my lord. By virtue of the order of this honorable court, I got appointment on 12/10/2022.
All right. Counsel for the appellant states that although part relief was granted to the appellant by the impugn order by requiring the respondents to reconsider his case for appointment in the post of OASF constable, and the respondents have in fact implemented the order by appointing him as such with effect from
On 12/10/2022.
12/10/2022, his appointment should date back to when less meritorious candidates were appointed as OASF constable. That is with effect from when were they appointed?
Sorry, my lord, I could not reflect that.
All right. So appointed. Stop. He states that the appointment should have been granted on notional basis from the earlier date. Paragraph limited to the above issue notice to the respondents. Mr. Das accepts notice on behalf of opposite party. Who is this Ashok Kumar Giri? He's a less meritorious candidate, is it?
Only one. When opposite notice is to be issued, opposite 3 and 2 extra could be 1 and 2.
No, he is for 2, I think. Commandant OASF will be yours, right?
Yes, 1 and 2, my lord. Chairman says
1 and 2. All right. Notice will now issue to respond with 3 returnable. August 28th.
Obliged.
Item number 40.
My lord, on behalf of Mr. Bibhu Prasad Tripathi, Lord, there are some defects as per the noting. 5D is there.
This is a 2021 matter, sir. What is it about? Tell us.
My lord, my senior will argue. Actually, I'm not empaneled for Bhubaneswar Municipal
Pass over.
Corporation.
All right.
Okay.
Pass over. Yes.
Item 41.
What kind of no instruction?
No instructions dismissed.
Item 42.
None appeals dismissed.
Item number 43.
43 also no instruction.
No instructions dismissed.
Item 44.
44 DLR regulation 25th September.
When is the
Yesterday's matter. Fresh matter. Notice.
notice return with 25th September. Delay condoned, is it? What's the delay? Is it COVID?
108 days.
No delay, ma'am.
Delay condoned. Right.
Item 45.
45 also same.
Same. 25th September. Right. Notice return. Right.
Item 46.
46 same.
Same.
47.
None of this is
Item number 48.
same order.
Item 49.
So right now, 49.
May I please?
Permission actually, I have been requested to. The original council actually is sick.
Okay.
But today morning actually they came. If you are fixed next week, I can.
All right. Counsel for the appellant stated to be unwell. List on. We'll have it later.
My lord, I am BC, my lord. My lord, I am on BC.
Whom are you appearing for, sir?
49 days.
It's 49. Mr.
Please, your
Ramesh
lordship.
is suffering, Lord.
Is Ramesh.
Huh.
I will comply I will rectify those. My lord. My lord.
Which item?
Okay, item. This is a different item. Sorry.
My lord.
Maybe call on.
Item 50. Sorry. Pardon.
50.
28th August.
Item number 50.
I filed a petition for leave because we are not parties before the Honorable Single Judge. The fact of the case, my lord, the petitioners are here, appellants are the legal heir of the deceased employee who was serving in the New India Insurance Company who died in harness due to COVID. And another lady
claiming to impersonate herself the wife, though she is not the legal married wife, and filed a writ application here without support of any document, even a legal certificate also, and got an order at page annexure 16, page 70. Though it is innocuous, my lord, now by that innocuous order creating trouble for us to get the benefits. The wife and children, they are not getting the benefits of the pension and other retirement benefit because of this order. No document he has filed before this honorable court to establish.
Have they implemented the impugned order?
No, my lord, because now we have tried their level best with the document that where I've been the authority, where the legal heirs. So give the benefit. They say the High Court has directed us. So they are now sitting over the matter.
Oh, so they're not giving benefit to either of you?
Either of me or that person. But we are the person who are entitled to this.
All right. Notice returnable. Twenty-ninth August.
Item 51.
That order
is what happens. So they're already sitting on that file.
Yes.
Item number 51. Item
58. Due to some poor video connection, I am unable to submit my letter. I don't know 48, my letter.
What is that?
Item number 48.
So tell us, what is 48 about?
My lord, it is about a cooperative implementation of RTA Act in the cooperative societies, primary agriculture cooperative society. It is already a covered matter by Honorable Apex Court in the Thalapalam judgment, my lord. Already, Honorable Apex Court has decided that the cooperative society which are not substantially financed by the government are not coming under the purview of the RTA Act. So, on that basis, I have filed a writ petition challenging the notification of register cooperative society Orissa, and that during a COVID pandemic period, I cannot appear through video conference due to some problem, my lord. That's why Honorable Single Judge has decided it as it is a 2012 to 2012 matter. So it is infructuous, but it is now on basis of this circular.
Not infructuous here. You're reading the impugned order wrongly. Does the learned single judge use the word infructuous?
No, not infructuous, my lord. It is as it is a belated stage, at highly belated stage.
So there is a difference, no, sir, between these two things? Isn't there a difference between these two things?
Yes, my lord.
So what are you supposed to tell us now?
Well, actually, this order is in force till date now. On basis of this order, people are applying to the primary agricultural cooperative societies, which is not coming under the purview of the RTA Act, my lord. Hence, this matter may be taken up and the notice may be issued to the opposite parties to answer.
So you are supposed to explain the delay in approaching the court. How have you explained the delay?
No, my lord, I have already filed a representation before. Yes, my lord. My lord, I have approached to the register annexure, my lord, annexure B, that is at page number 24, narrating all the facts to the registered cooperative societies, my lord.
When
but he is still
1 minute. So when was the day? When was this representation made?
This was made on 25th 9th 2019, my lord.
What were you doing till then, sir?
My lord, 25th 9th 2009.
What were you doing, sir? Why did you approach the
July
registrar so late?
My lord, it's a new act. So,
which is the new act, sir? Which is a new act?
No, Act of 2005, my lord.
So how come you're going in 2019? How are you explaining the delay?
No,
delay at every stage, sir.
The cooperative societies are independent bodies registered under the Cooperative Society Act, but it's registering authorities on the RCS, my lord. RCS passed an order in the year 2012. That order is in force till date, my lord. On basis of that order, the peoples are applying for information under RTA Act to the cooperative societies at this stage, my lord.
Mr. Dash,
My lord,
have you understood the question?
I beg your pardon, my lord.
Do you remember we asked you any question, or you don't remember that also?
Yes, my lord.
What question did we ask you?
It is a matter of 2012. My approach is at 2019. My lord. My lord, actually, people are applying this act is as per Honorable Apex Court's verdict. This act is not applicable to the cooperative, primary agricultural cooperative societies. So now people are applying for information under this RTA Act, my lord. So that's why the cooperative societies of Sonpur district approach Honorable the registered cooperative society for a direction on it. And the RCS is silent over this matter.
Absolutely. Very sorry to note, sir, you're unable to make out a point at all. The whole issue is about delay, and you're unable to make out a point. You have no dates to give us, nothing.
My lord, it may adjourn to some other date. I will explain everything, my lord.
Sir, you have to first be clear in your head what the issue is. You don't even seem to be clear what the issue is. Counsel for the...
My lord, the issue is...
No. Don't start all over again now. You are unable to answer the basic question we are asking you. So you keep arguing something which you think is the issue. The whole problem is that. Counsel for the appellant to explain the issue that has been pointed out by the learned single judge, namely that the appellant approached the High Court for relief in relation to the order challenged in the writ petition, that is the order dated 12th June 2007. Orders dated 12 June 2007, 1st November 2011, 9 January 2012, and 28 July 2012. Only on 17th March 2021. So in other words, the appellant was required to explain the inordinate delay in approaching the High Court for relief. So the writ petition has been dismissed on that ground. Paragraph, despite repeatedly asking counsel for the appellant to explain why there was so much delay in approaching the High Court, he is unable to offer any explanation, and has simply asked for an adjournment. Paragraph, in the interest of justice, list on 29th August 2023. The appellant will prepare a note of his submissions explaining the delay for the next date.
Item number 51. 51 DLR matter 25th September.
All right. Fresh matter, or this is after notice?
Fresh. 52, 53 also said.
So you'll have to say notice returned 25th September.
Item number 54.
Delay
54 RSV matters similar to 28.
What is 28? Yeah. So notice list along with writ appeal
65 of 2020
on 28th August.
Item number 55.
May I please, madam? Actually, even I have informed that the man is expired in the meantime.
Or counsel.
So therefore, I crave substitution of the pension case. I pray substitution, madam. So for time is on time granted for substitution because pension case, madam.
When did he die, sir?
She died on, my lord, that is given on 25, 12, and 22. And yesterday evening, I had telephoned him that the doctor informed us he has died in the meantime. And I have given the certificate, the copy of the death certificate.
No, it's okay. What date is it? Appellant died on 25th February 2022 itself.
22/12, my lord. 24/12. 24/12, my lord.
I'm not able to understand. What is 24/12?
25/12 and 22.
I'm not able to hear.
He died on 25/12/2022.
December. 25/12/2022 and wants to file an application for bringing on record the legal representatives of the appellant. Listed on 29th August.
Item number 56. Item 56.
Nana Pace.
Item number 57.
Same order.
Item number 58.
Item 15 by 25th September.
Notice returnable 25th.
59, 60,
So
61,
delays
62,
suspension is allowed.
63, 64. All are DLR 25th September.
59 to 64. Item number 65.
65 may I plead, my lord. Here is the case, my lord. When the prisoner was subjected to transfer for that 4 times within a span of 2 years, he approached this honorable court in WPC number 38101 of 2020.
It's all infractious now, sir. Transfer orders must be infractious.
Well, what has happened, my lord? This honorable court in that writ petition directed to take a decision on the representation of the prisoner and further directed to maintain the status quo, my lord. Thereafter, my lord, what has happened? The authorities have issued again another transfer order without taking any decision on the representation. Challenging that transfer order, the prisoners approached in the subsequent writ petition, that is WPC number 17870/2021. My lord, the honorable single judge has disposed of the matter, taking into account that there has been no
Disposed of or dismissed?
Disposed of, my lord.
Not dismissed. I see. Disposed of.
Yes, my lord. Disposed of the writ petition on the ground that there was no violation of the honorable court.
There's one paragraph before that, disposed of. Read that.
Considering the contentions raised by the learned counsel.
After that, there is one paragraph.
In that view of the matter, there is no violation of the court's order. More so, since the new incumbent has already joined the additional Tehsildar in the office of Tehsildar Hemgiri, and the prisoner has joined in new place of posting, that is Tehsildar Balisarankara, as additional Tehsildar, all on dated such and such. All other access shall be academic. My lord, what has happened, my lord?
This is not correct.
This is correct, my lord.
Now we want us to interfere so that he can now stop functioning as additional Tehsildar wherever from 19/5/2021. Last years,
my whole submission is that
2 years he's been there. Now we'll interfere to put him back after he has served for 2 years in the transferred post.
My humble submission is,
however humble it is, sir, it may be the most humble submission, no doubt. Your humility, we are not doubting at all. But what's the point in interfering? You tell us. The man was challenging his transfer order.
Yes,
so on 19/5/2021, after everything he lost, he went and joined in that post. Correct?
Yes.
Today, in April 2023, you want us to say, no, he should not be transferred.
My whole
You're seriously arguing that?
No, my whole submission is
that shall we impose heavy costs? You can make your submissions. We'll listen to you very patiently. But you're really abusing the process of court. After joining in a transferred post on 19 May 2021, in April 2023, you want to still argue that your transfer was wrong.
I submit that no instruction.
Counsel for the appellant is unable to dispute that the appellant has already joined the new place of posting where he was transferred way back on 19th May 2021 itself. This is what has been noted by the learned single judge while disposing of his writ petition by the impugned order dated 4th August 2021. Paragraph. Clearly, the cause of action does not survive. The writ appeal is dismissed.
Obligation.
Item 66.
None appeals dismissed.
67.
May I please, your lordship? My lord, I have filed the IA number 2157. Let the matter come with the IA, which is regarding limitation.
Forget about that, sir. Tell us what the matter is about.
My lord, I have filed the writ appeal for passing of the impugned order under Annexure 2, as the matter has already been adjudicated by the division bench of this honorable court in writ appeal.
What does the impugned order do?
Well, impugned order was passed, the writ petition was pending. Thereafter, writ appeal was disposed of after 2 years of the writ petition filed by the respondent number 5. In the writ appeal, the matter, the same self issue was disposed of. So my prayer is,
I have not understood, sir. Sorry. Pardon me, sir, for not understanding. But what is the impugned order? This impugned order is 24th March 2021?
My lord, impugned order was 24/3/2021.
What does it do, sir?
To dispose of the representation.
Whose representation?
Of the petitioner. The matter.
So you don't want your representation to be disposed of. You're unhappy that your representation is being asked to be disposed of.
No, my lord. That matter has already been disposed of by this honorable court in writ appeal number. My lord, kindly see Annexure 1, page 21 to 25. My lord, my appointment, my lord, the appointment of the appellant has and respondent has already been adjudicated upon. My lord, kindly see page 14. My lord, I have quoted the order. Accordingly, the impugned order dated 6/2/2015 passed in WPC number is hereby quashed. The selection and appointment of appellant as Anganwadi worker of Natime Anganwadi Center is upheld. My lord, I was the appellant. My appointment was upheld. The writ petition was pending prior to adjudication of the writ appeal, and that was.
Not able to understand it. So, Sabita. Petition in which the impugned order was passed has not been filed by you, sir. It was filed by the opposite party.
My
respondent.
My
You're not explaining that.
My lord,
repeatedly asking you, you say you filed the writ petition. You did not file, sir. The opposite party, the respondent filed the writ petition.
My lord.
Why didn't you say
my
that?
Lord, the respondent was challenging my appointment. That was finally adjudicated in writ appeal number 64 Annexure 1.
All right. So when they deal with the representation, they'll tell her that. That's as simple as that.
My lord,
when they deal with her representation, they will tell her this has already been adjudicated. That's the end of the matter.
My lord, that matter has already, it is hit by constructive res judicata.
There's no question of what was the date of this impugned order? You tell us.
My lord, it was 24/3/2021.
Which is how many years ago?
After 2 years of passing of the writ appeal order.
No. How many years have passed since then?
3 years.
2 years. I have filed, the appeal was filed in 2021.
All right. So no stay, nothing granted. Correct? It has not even come up once, sir. Today it is coming up because in the normal course we have asked these petitions appeals to be listed. So in the last 2 years, what has happened?
My lord, that is pending the order. This court directed for disposal of the representation. That is pending, my lord.
So everybody is just sleeping. Nobody is worried, sir. The government is not worried. Your opposite party has not worried. Although the opposite party got an order in her favor, she's not worried. She has not asked why you are not disposing of representation. The state government is saying, I will not dispose of representation. So nobody's under any worry at all. You have anyway succeeded, you are working, correct?
My lord.
See, everybody is happy and peaceful. Unnecessarily, you've filed this writ appeal. Nothing is happening anywhere. You are working, correct?
My lord.
Without any disturbance.
My lord. My lord, when the impugned order was passed, I was not, no notice was issued.
Not necessary, because they didn't want you to unnecessarily spend time on litigation, engage lawyer and all that. Because it was an innocuous order.
My lord, my appointment.
Harmless order. If that said, no, remove you from service and appoint her in your place, then you should be worried.
My lord.
Nothing of that sort.
My lord, the matter has already been adjudicated.
Correct. And they are aware of it. Correct. The state is already aware of it.
My lord.
Nothing to worry, sir. The impugned order requires the state to consider the representation of respondent number 5, questioning the appointment of the present appellant as Anganwadi worker of the Natimi Anganwadi Center, Ranpur, in Niagar district. Paragraph. Counsel of the appellant states that apart from the fact that no notice was issued to the appellant in the writ petition, the issue has already been adjudicated by an order passed by the division bench on 2nd April 2019 in writ appeal 64 of 2015, where actually in that writ appeal, she was not heard.
She was party,
but not heard.
My lord, she was contesting. My lord, kindly see.
All right. Okay. Involving the issue has already been adjudicated. And the appointment of the present appellant as AWW was upheld. The above factor will obviously be taken note of by the state while dealing with the representation of respondent number 4. Consequently, the court sees no reason to interfere with the impugned order. The writ appeal is disposed of in the above terms.
Item number 68. 68.
None appears.
Item number 69.
69 RSP is similar to item 28.
28th August.
28th August notice and list along with
62 of 20.
62 of 20. What?
Item number 70. May I please, Lords?
Sir.
My lord, retired employee entitled after his death, I applied for family pension, my lord, being the legally married wife after the death of the first wife. Now, the pension papers were regularized. Your lordship, annexure 2, page 12. And after his death in 2018, when I made application, somebody else, she comes and challenges, seeks that I am also married wife of late Parida. Accordingly, the family pension has not been released in my favor.
Basically, they've said go to the civil court to decide.
My lord, may visualize there is no concept of a second wife in either.
You can't visualize, sir.
Yes, legally married wife. Yes, your lordship can visualize, can see your lordship. Why visualize? Your lordship, the
only civil court can visualize.
No, my lord.
Yes, yes.
There it is, your lordship, because there is an order. I am telling why 56 6D note. after the commencement of Hindu Marriage Act, 1955, the second marriage contracted by a Hindu male, even if that third wife is say that is a second marriage, if your lordship says, first is dead. After her death, I got married to him in 2007. After death, I made application for family pension. Then this lady comes, the third lady, my lord. After the commencement of Hindu Marriage Act 55, any second marriage contracted by a Hindu male during the lifetime of his first wife shall be void, and the second wife shall not be entitled to the family pension as a legally wedded wife. And family definition as per OCS pension rules, my lord, your lordship knows, wife in case of a male government servant or husband in case of a female government servant. We are not talking about children's right and all that, your lordship. It's a wife's entitlement to a family pension. And documents, if your lordship would look at page 11 and 12, 12 and 13, even the joint pass 12, your lordship may kindly look at page 12, annexure 2. With reference to the subject cited above, it is to intimate that Sir Virendra Kumar Parida, the ex-head clerk, retired on 31/3/2000, and his pensionary benefits has already been settled by such and such, along with family pension in favor of his wife, Srimati Savitri Mani Parida, who has died, as I am saying, my lord. But after the death of Savitri Mani Parida on 15/6/2007, Sri Parida has submitted the relevant documents for sanction of the family pension in favor of his second wife, namely Urmila Parida. But the question of family pension will arise only after the death of Sri Parida on production of death certificate.
So what has happened to Mr. Parida?
My lord?
Mr. Parida died.
Parida died, and I am Urmila Parida.
No, when did he die?
He died in 2018.
18. Okay.
2018, 8/1/2018.
Now she claims, this other woman claims, when did she claims that he married her?
See, I don't have that information, but response to your lordship's direction, that this is a third round of litigation, my lord. The authorities say at page 41, my lord, S40, that was in response to my representation, in pursuant to order dated such and such of the Honorable High Court, your application for sanction of family pension disposed of with the following observation. Your application dated 29/3/2019 for sanction of family pension was forwarded to the HR wings of such and such by this office letter number 27/1/2020. However, during scrutiny of the said application, it is found that the family pension cannot be sanctioned in favor of the claimant as per OCS pension rules, and the same has been communicated by letter dated 6/3/16 dated 12/5/2020 to the AGM. My next page is that letter which is referring. On scrutiny of the documents which have been forwarded by your office by letter number such and such, it is to intimate you that the combination of components or elements available with the representation documents of the claimant makes it abundantly clear that the family pension cannot be sanctioned in favor of the claimants as per OCS pension rules. Therefore, you are requested to dispose of the representation of the claimant accordingly under intimation to this office. There is nothing on record to show that it is there, but there is whispering that there is a third wife for which it is not being released.
No, where did we get this third wife? Where did they communicate that?
Third wife, my lord. See, chitta kya idhar? See, uthre kohila are not matching.
Actually, they've given you 4 reasons why they are rejecting.
Your lordship?
There are 4 reasons. Come to page 30. You have your writ petition, annexure 12.
Writ petition, my lord.
There's a letter dated 17/10/2019, written by you trying to clarify the points indicated in a letter dated 31/8/2019.
My lord, I will pray that letter.
You don't have that.
Letter dated?
See, sorry, it is a letter dated 17/10/2019, written by you,
my lord,
to the UNESCO, in which you are trying to explain the
yes.
four points of doubt.
Yes. That they had sought for some clarification. There, this third woman, my lord, this lady.
No.
Claimed,
so this is not the only ground.
No, other grounds, those have been, because there are, now your lordship, in the first wife, there are some children. Through me, there are some children. Now somebody else has also come up saying that he was my father. So those ambiguities, those have been clarified. Now it is a question of my entitlement.
No, we are talking the date of marriage, sir. See, what's the date of marriage of that Subhadra Parida?
Date of marriage is your lordship.
Whether she is the second or
Second, my
she's
lord.
the third
Annexure 3. Annexure 3 is the date. That has been clarified on page 12, my lord.
Where? Annexure?
Annexure 3 is the marriage certificate.
Or whose marriage certificate? No, it is your marriage certificate.
My lord.
This is a marriage certificate of 17 January 2013.
13.
The other woman, she claims, when did she claim she was married when?
That will be clarified on page 12, my lord. And not about her entitlement, but my status vis-a-vis the deceased.
No, sir. I think you're not answering the question. The woman who's now setting up a rival claim, she must be claiming that she got married on a particular date.
There is nothing like that.
No. Can't be nothing like that.
Yes,
obviously.
my lord.
So there has to be some date given by her.
I agree with your lordship. There has to be something, but there is nothing on record to show that. Neither the authorities are disclosing. And my instructions are she may be an imposter also. Because as far as my entitlement
No, so you've not made her a party because you don't know who she is. Have you made her a party here?
I didn't make her a party in the writ petition. That's why possibly I have not made her a party here.
They did not file a counter affidavit in the writ petition.
No.
It was disposed of without a counter.
It was disposed of without a counter, your lordship. Yes, first order, page 44, order number 1. It would have clarified.
So we can send it back then. Let a counter affidavit probably filed.
Yes, your lordship.
All right. The appellant has been approaching the respondent of one company for grant of family pension after the death of her husband, who was working as head clerk in the said company on 8 January 2018. Full stop. He based a claim on the basis of a marriage certificate dated 17 January 2013, which shows that after the death of his first wife, her deceased husband married her on 17 July 2007. Paragraph. It appears that on 25th March 2019, she made an application for grant of family pension, which was rejected. On 31st August 2019, on 4 grounds. One of which was that a similar application for family pension had also been received from single quotes Subhadra Parida, declaring herself as wife of late Virendra Kumar Parida. Unquote. So no details of when this application was received and what is exactly claimed in the said application by the said Subhadra Parida was not indicated. Paragraph. In the impugned order, the learned single judge has disposed of the writ petition on the very first date, relegating the appellant to the civil court without even a counter affidavit being filed, without even any counter affidavit being called for from the respondent company. Full stop. The learned single judge has observed that since a rival claim has been set up by another woman, the matter can only be resolved in the civil court. Paragraph. Without the full facts coming on record, it would not be possible to ascertain whether the rival claim was in fact bona fide. And no, bona fide, full stop. It was necessary, therefore, in the circumstances for a counter affidavit to be called for from the company next. For the aforementioned reasons, the impugned orders hereby set aside, and in petition civil 23386 of 2021 is restored to the file of the learned single judge, the roster bench, where it will be listed on 17th May 2023. Paragraph. The learned single judge will proceed further in the matter after issuing notice to the respondents in the writ petition and ascertain from the respondent number 1 company the name and address of the rival claimant so that she can be made a party to the writ petition. The writ appeal is disposed of the above.
Sir, namaste. Item 71. Item number 71.
Item 71, outsourcing 8th August.
8th August. It's a fresh matter.
8th August.
This is first time.
First time.
So notice returnable 8th August.
Item 72.
72, 73, 74, 75, 76, 77. Sartapada 8th May.
So notice returnable.
77.
77 is a private matter.
Sorry, 76.
76. Okay.
Item 77.
None appeals dismissed.
Item 78.
78, rehabilitation assistant, 38 minute.
So notice returnable 38. There should be stay in the
Item number 79.
Sattapada, 8th of May.
Right.
Item number 80.
It was similar to yesterday's matter, 25th of September, DLR regulation.
All right. Notice returnable.
Item number 81.
8th of May, Marad, Sattapad.
All right.
Item number 82.
None appeals dismissed.
Item number 83.
This is appellant was a police constable. He was terminated for unauthorized absence for 74 days. His case that his wife was sick on account of pregnancy and he left that place and the inquiry was conducted expected. My lordship kindly see has terminated annexer 2 of the writ petition finals you can see. Only because he has not filed any show cause against the charge sheet and it was dismissed. Thereafter, he filed appeal. Passing of order of
dates are very important, sir.
My lordship.
Dates are very important. So kindly tell us date-wise what happened.
Date-wise, my lordship. The petitioner was appointed in 1990.
No date, only the year you know. You don't know the date.
I will give you a date chart.
Please, that's not like this, sir.
Yes, next.
What is the main ground on which your
main ground
has been thrown out?
Can see that in 1990, he was joined in 1990, my lordship.
Sir, if I tell you I became a judge in 2006, you will be happy knowing that. You don't want to know the date.
I am giving my lordship, the petitioner.
Are we troubling you too much, sir?
My lordship.
Are we troubling you too much? You are making it appear. Why are you unnecessarily troubling me like this? That's your tone.
I'm sorry, I'm not communicated properly, sir.
What is the main ground on which the
main ground, my lordship? He was absent.
Sir, what is the main ground on which the single judge has dismissed
my lordship? the Lord Singhal has believed that his wife was sick.
No, sir.
Yes.
That is not the ground on which the single judge has dismissed your writ petition.
Second ground is on account of delay, my lordship.
That's the main ground,
Yes,
sir.
yes. My lordship, can see the date I am mentioning, my lordship, can see Annexure 1 is the termination order. Last order, my lordship, can Annexure 1, my lordship. First order of termination. Annexure 1 of the writ petition as at page 2 at page 13, my lordship. That is the order of termination. That is dated 15/10/1998, communicated on 31/10/96.
When did you file the application?
My lordship, that object thereafter was filed appeal. Appeal was dismissed. Then he made a representation. Annexure 4, my lordship. That also dismissed on the ground that he could not produce any material to the effect there is no other member of the family to look after his wife in his absence. That is the ground.
On merits, you were absent from service for 74 days.
Yes, ma'am. There is your order of termination.
No. So what is your explanation? You're a constable, right?
He is a scheduled tribe constable.
So what?
Yes.
He's absent for 74 days.
Absence, he has said that his wife was sick and there was
No, but without an application for leave, how can
he
he just
has not
disappear?
taken any application, only verbally intimated. There is no dispute about that.
Then
that fact is
then how do you explain this, sir? Staying away for 74 days. 74 days is more than 2 months.
74 days he has not.
More than 2 months as a constable, you can't afford to stay away.
Before
Sir.
leaving, he has formally informed the co-worker as well as the authority concerned.
That's not possible, sir. This is the problem. These are all disciplined forces.
What I pray, there is no factual that is correct. What I pray, my lordship may direct state government to take instruction without any backwardness whether he can be adjusted.
What is all this?
Just scheduled tribe person.
No question, sir. These are all disciplined forces. These are.
Yeah, that's I understand, man.
Yes.
I'm not
correct.
If anything can be done, man.
People are desperate.
He's an illiterate person, man.
This job, sir, there are 10,000 people waiting to get appointed.
He's illiterate class of grade up to class.
They all know, sir. Everybody knows that you can't stay on leave for 2 months without informing anybody. Everybody knows that. You see, the present appeal is directed against an order dated 22nd September 2021, passed by the single judge, dismissing writ petition civil bracket OAC number 7696 of 1999, filed by the present appellant. Questioning an order dated 15/10/1996, passed by the DIG of Police, ETC Anugul, dismissing the appellant from service as constable for unauthorized absence from 28th May 1994 to 10th August 1994. That is for a period of 74 days. Full stop. Also challenged was the order dated 9/11/1998. Sorry, 25/10/1998 of the Director General of Police, Orissa, dismissing the, rejecting the appeal of the appellant. Rejecting the representation of the appellant against the dismissal order. Paragraph. The learned single judge has dismissed the writ petition on two grounds. One of which was that the appellant had approached the Odisha Administrative Tribunal (OAT) against the dismissal order belatedly. Full stop. As far as this ground is concerned, the court notes that the appellant exhausted the remedy of an appeal before approaching the OAT. Full stop. The appeal was rejected on 25/10/1998, and the application, the OAT, was filed in 1999, and therefore it cannot be said that the said application was barred by laches. Paragraph. However, on merits, the learned single judge noted that with the appellant not having any valid explanation for being absent from duty for 74 days without intimating anyone, it was a serious enough misconduct for which the punishment of dismissal from service could not be said to be disproportionate. Paragraph. As noted by the learned single judge, prior to the order of dismissal, there was due compliance with the principles of natural justice, with the appellant being issued a show cause notice and a full-fledged inquiry being held thereafter, in which witnesses were examined on behalf of the department. An opportunity was given to the appellant to cross-examine such witnesses. Paragraph. The appellant was unable to dispute that he proceeded on leave for 74 days, purportedly on account of his wife's illness, without any intimation to anyone. Full stop. Being a constable in the Odisha police, he could not have been unaware of the consequences of staying away from duty for such a long period without any permission from the competent authority. Paragraph. Consequently, the court is unable to accept the plea of the appellant that the punishment of dismissal from service for the above misconduct from a disciplined force like the Odisha police was excessive and requires to be interfered. The net result is that there have been no grounds made out for interference with the impugned order of the learned single judge on merits. No grounds made out on merits for interference with the impugned order of the learned single judge. The appeal is accordingly dismissed.
Item number 84.
84, my lord, notice was issued on the last date, my lord. We have filed requisite, but my lord, little
Okay. The
late, my lord,
requisites-
regarding acceptance.
What is this matter?
This is, my lord, Lord, may kindly see here. The learned single judge has directed for release of family pension. That is not a problem, but my lord, with 6% interest. That is not provided in the OCS pension rules, my lord. Our ground is that during the pendency of the application, while it was processing, the payment has already been made. While the matter was being processed by the department, the learned single judge is directed for payment of 6% interest. Whereas in the meantime, my lord, the pension has already been paid. Lord, may kindly see page 7, my lord. We have given that date.
All right. You see, the requisites stated have been filed late, be accepted for fresh notice to the respondent. Returnable. Second August.
Well, item number 85.
May I please? Let's turn to page 16 in the impugn order. Page 16 is the impugn order. Prior to that page impugn order, let's turn to page 14, annexure 4. Well, he submitted his file through offline. That was rejected because in view of that circular at annexure 7, annexure 7, page 21. Online submission of PAR was mandatory from the year 2015-16. Honorable single judge on the first day directed to accept his PAR on offline and consider his case for promotion in the DPC.
Oh, you simply set out the impugned order in the writ appeal. You've not enclosed the impugned order.
The page 16, my lord. 16.
16, is it?
My lord.
All right. Sorry. What is the harm? So you must have implemented this by now.
No, not implemented.
How can it for 2 years you've not implemented?
Because that PAR was not accepted in view of that.
No, now the entire DPC is held up. Nobody's got promotion because of this.
In fact, that has not been implemented.
How can it be, sir? You're just harming so many other people also because of this.
No, others have got promotion in the meantime. TPC.
No, but you had to implement this. How can you, without a comparative assessment, you can't?
No, in respect of this person only, because of so far as others are concerned, their case has been considered those who have submitted PAR online, because the submission of PAR online has been become mandated from the year 2015-16. You'll also find it from annexure 7 with notification. Page 21.
No. What was the delay? What was the reason he gave for not submitting it online?
He has not submitted. He has submitted all PARs on through offline.
No. When did the system start?
Yes, that I am showing page 21, my lord. Annexure 7. It started from 2014-15 and it has become mandatory, compulsory from the year 2015-16. Page 21.
No. Come to para 5 of the writ petition.
Writ petition, my lord.
Yes.
Well,
in fact, there was a circular guideline issued to all heads of department intimating them inter alia to send the hard copies of PIRs of employees who could not submit through online for promotion of their cases. That's a circular 25/1/2021.
Para 7, well.
Yes. In fact, he forwards the hard copy to the reporting cum reviewing authority, and he accepted them and endorsed remarks therein. So even the reviewing authority accepts the hard copy and then sends it to the accepting authority.
Your Lordship, Annexure 1 to that, he has relied upon that Annexure
Guideline, correct. The guideline is that, photocopy the guideline.
Your Lordship, in writing reference, I am to state that on one-time relaxation was allowed.
Correct.
Your Lordship, in one-time relaxation was allowed therein for consideration of promotion of employees up to the including Group B employees of the state government on the basis of available either online or offline from up to 2018-19. The online submission, however, was made mandatory from 2019-20 and thereafter. In the meantime, it has been brought to the notice of that promotion of Group A officers could not be considered due to want of online CCFR both for 22 and anticipated. It is required inform on all such cases where promotion of Group A officers could not be considered due to non-available of online PAR, though through hard copies are available, may be intimated views may all be.
Correct, sir. So they are still permitting hard copies to be given.
Because in respect of Group A officers,
whatever, sir. All departments of government, all heads of departments, everything. So this could not have been a valid ground. You say the challenge of the present petition, appeal, sorry, is to an order dated 17 March 2021 passed by the learned single judge, disposing of writ petition civil 9946 of 2021 filed by the respondent, requiring the Departmental Promotion Committee, DPC, to take into consideration the hard copies of the performance appraisal review, right?
Report. Performance appraisal report,
Report. Performance appraisal report, PAR, submitted by the respondent, single quotes offline. Paragraph. Mr. Kuntia argues that by virtue of instructions issued to all departments way back on 14th January 2016, the submission of PAR online for the purposes of promotion became mandatory. Stop. He submits that inasmuch as the respondent did not submit his PAR online, the learned single judge could not have compelled the DPC to consider his case for promotion on the basis of the hard copy of the PAR submitted single quotes offline. Unquote. Paragraph. It is seen from the pleadings in the writ petition that the respondent specifically averred in para 5 that he was having genuine difficulties in submitting the PAR online, open quotation, because of non-supply of computer and due to renovation and infrastructure building construction in the office of the PCCF Orissa, full stop, unquote. Further, it appears that the respondent submitted the PAR in a hard copy to the reporting cum reviewing authority, who in turn forwarded it with his comments and with his remarks to the accepting and forwarding authority. Full stop. Since it was lying with the latter, the petitioner, the respondent's case was not considered for promotion, leading him to approach the High Court. Paragraph. Importantly, the respondent enclosed with his writ petition copy of a state government letter dated 25th January 2021, noting that employees were having difficulties in submitting the PAR online and should be permitted to submit hard copies of the same. paragraph. Clearly, the above letter of the state government, which has not been disputed by the appellant, anticipates difficulties in the employees submitting the PAR online, even as of January 2021. In the circumstances, the direction issued by the learned single judge to the appellant to accept the PAR submitted by the respondent in a hard copy and thereafter consider his case for promotion does not call for interference. The writ appeal is accordingly dismissed. Contempt list before the learned single judge on 10th July 2023, by which time the direction issued in the impugned order of the learned single judge should be complied with by the appellant.
Well, your lordship direct will comply within 4 weeks.
No, so we've listed it on 10 July.
Because there is so much contempt has been.
So that contempt, I'm asking it to be listed on 10 July.
Yes, today's list before my lord single. The contempt, so much contempt is there. Like this.
Yeah, we're asking it to be listed before the single judge.
Yes, we will comply within 4 weeks. That contempt can be disposed of so that.
Why dispose of, sir? It will be listed before the single judge in the roster bench.
Yes, yes.
In fact, I've given you more than 4 weeks. So maybe we should say 27 June.
No.
Or at 10 July. Which time the impugned order should be complied with. All right.
Item 86.
May I please, ma'am? Yeah, appellant challenging the order dated 7/12/2022 passed by the learned single judge, my lord. It is a case of the petitioner that petitioner is a SCVC candidate, my lord. Applied teacher post had annex at 46, my lord, under SCVC, my lord. At the time of the applications, petitioner applicant age was 36 years, 7 months, 22 days, my lord. But the opposite party respondent selected under the unreserved category to the petitioner, my lord. According to the order of the learned single judge at page 54, my lord.
No. What is your grievance?
Grievance is the appellant is a SCVC candidate, my lord. Applied under the SCVC category. But the respondent selected under the unreserved category to the petitioner.
So what is the prejudice cost to you?
Regarding the place of posting, the petitioner, if the petitioner is selected under the SCVC category, he will join in the home district, my lord. The petitioner posted on the Navarangpur district serial number 28 of the preference.
But the single judge says you gave Navarangpur as your preference.
My lord, already it is a mandatory, my lord. All 30 districts should be mentioned in the application form, my lord.
No. So you opted for Navarangpur.
My lord. At page 47, my lord. One is preference Jajpur and this Navarangpur is 28, my lord. 30 districts should be mentioned in the application form. Otherwise, the application cannot be accepted, my lord.
You mean 1 to 30 preference you have to give?
My lord.
First preference was Jajpur.
Jajpur, my lord.
And Navarangpur was which preference?
28, my lord. Serial number 28, my lord.
Oh. I see. When did you join, sir? You've joined or you're not joined? You've still not joined?
No, man.
Why? You will lose your job then if you don't join. Why are you taking such a risk? What makes you think they're waiting for you? There must be a joining date, no? Isn't there a joining date?
Yes, miss, there is a joining date, but
then you have missed the joining date.
86 copy.
No. I'm not solved a copy.
No, but you were supposed to join when? 2nd March 2022 was this posting order, sir. They rejected your application on 2nd March 2022.
My lord. That after that, the petition challenges writ petition
No,
before
no,
the
but how can you just stay back at home? You don't have to go report for duty. What is this? What is the system here in the state government? They can join whenever they like.
No.
Ah.
A time limit is given.
What time limit? He
7
doesn't
days.
seem to be aware of any time limit. He
Normally-
says I can join whenever I like.
Normally,
1 year is over now. He's very relaxed. He's at home.
no, there is a provision under Odisha Service Code joining time. 7 day time is given for fresh apprentice.
Ah.
If there is some difficulties, he can seek for a time extending for a period up to 30 days.
Then how does this work?
No, petitioner is not, appellant is not joined, man. Challenging.
Where's the question of just challenging and keeping quiet, sir? You can challenge and keep quiet. Today, if this writ appeal has not been listed today, it would have been listed some 2 years later. It's because I'm causing all of you great grief. You never wanted this writ appeal to be heard. I'm asking the registry to list it all. So if I had not asked them to list it, it would have never been listed for another 2 years. So even after 2 years, we'll come to the High Court and say, now permit me to join in Jajpur. I don't know how this whole system works. How can you presume that you don't have to do anything? Has it not become infructuous then?
No.
Sir, if your appointment has been cancelled, it is infructuous, sir. Where's the question of...
That is another part, my lord.
What is another part? Where is the question of another part?
Challenging the error apparently.
You can challenge and keep quiet.
My lord.
See, the point is you challenge, but you keep quiet. You have lost your challenge, right? Single judge threw out your challenge in December itself.
My lord.
Single judge threw out your challenge. Threw out meaning rejected your challenge in December. Today is what date? On 7th December, the single judge dismissed your writ petition.
Disposed of, my lord. Not dismissed, disposed of by observing the order. The single judge order is not.
Okay. Did single judge accept your plea? Did the single judge accept your plea? Sir, did the single judge accept your plea?
No, my lord.
So when did the single judge not accept your plea? Which date? Which date?
7/12/2022, my lord.
Today, what is the date, sir?
26 April, my lord.
So what is your understanding? You don't have to report for duty. That is your understanding. What is the post you're...
Teacher.
Interesting to know what you're applying for.
Teacher.
School and mass education department. So you're a teacher. You're supposed to be very disciplined. Very good. It's amazing. It's obviously infructuous.
No, my prayer is the joining of the appellant is part is different, my lord.
It's
Here
not different, sir.
challenging the error committed by the respondent.
You're totally mistaken, sir.
My lord,
You're totally mistaken. You're totally mistaken. It's not a separate issue. It is gone. Train has left the station. Train has left the station.
Challenging the selection.
Train has left the station, sir.
Selection list.
You can keep challenging it for next 20 years. Train has left the station.
Selection list is under
you can't give yourself one extended time for joining by saying, oh, I have challenged. Now I don't have to report for duty.
I will take instruction whether petition is the appellant is join or not.
No instruction. If he has joined, let him be there wherever he is. We are not entertaining this. You see,
where the error is apparent face of record minor.
Sorry,
the petition applied under the SCBC category, selected under the unusual category, which cannot be accepted in the IF law, my lord.
You see, the challenge the present petition is to an order dated 7 December 2022, passed by the learned single judge, disposing of writ petition 15555 of 2022. The grievance of the petitioner, appellant, who was chosen for the post of contractual trained graduate teacher, bracket arts. Was that despite his having applied under the SCBC category and opted for Jajpur district, he was selected under the unreserved category and given appointment in single courts Navratpur district. Full stop. The appellant apparently made a representation. On 5th January 2022, which was rejected on 2nd March 2022. Full stop. In that letter, he was informed that his selection had been made against the vacancy of the UR category, as he had secured higher mark. And as per his position in the UR select list, he had been posted in Navarangpur. Full stop. Clause 11 of the advertisement clearly mentioned that a candidate of a particular reservation category shall be allocated to a district only against a vacancy of his or her reservation category. Full stop. It appears that despite the learned single judge, the paragraph, in the impugned order, the learned single judge has not accepted the plea of the appellant that he should have been considered under the SCBC category. Noting that he had given Nabarangpur as one of his choices. Paragraph. Throughout this entire period, it appears that the appellant never reported for duty. Full stop. This is surprising since the results were obviously disclosed way back in December 2021 itself. Stop. Counsel to the state informs the court that there is a small window allowed to the selected candidate to report for duty at the place of posting. And if he fails to do so, the candidature would stand cancelled. Full stop. In the circumstances, the court finds it unacceptable that without joining at Nabarangpur, the appellant still wants to pursue the matter and to be expected to be allowed to join at the place of his choice by treating him as having been appointed under the SCBC category. Paragraph. Be that as it may, with the clause in the advertisement being absolutely clear, the court is unable to find fault with the decision of the state to treat him as under the UR category because of his higher merit. Stop. There's no ground made out for interference. The appeal is dismissed.
Number 87.
May I please your lordship here, my lord, the petitioner, my lord, challenging the order of the honorable single judge. In the meantime, during the pendency of the appeal, some development has occurred. Let me take instruction next week, my lord, I pray.
What development is taking place?
My lord, in the civil suits, he has obtained an interim order of status quo. So therefore, my lord, I need some instruction next week, my lord, I pray for. Because the order, my lord, here the impugned arising out of a OPP proceeding.
See, this is all 227. It's not a 226 petition, sir. The
226 and 227, both, my lord.
No.
I'll satisfy your lordship, my lord, next week, any day, my lord.
11 and 13. What were you seeking relief from the
Lordship has, my lord has.
My lord, it is not, it is arising out of a OPP proceeding, my lord. It is under 226, my lord.
OPP proceeding
Huh.
227.
No.
You are seeking quashment of the order
Appellate
of the
order.
appellate order.
Appellate order.
That is under
My lord, I will satisfy your lordship, my lord.
And that
Next week, my lord.
There is a finding in the
Which is this
order.
premises?
My lord.
What are you?
My lord, I am a tenant under the state, my lord, after abolition of the estate, my lord. Under section 8 of the Odisha Estate Abolition Act. My lord, my suit is pending, my lord. I am not an unauthorized occupant, my lord. I am an authorized occupant. I am having an occupancy right over the land. So that has been, my lord, the Honorable Single Judge has said that you challenge the order before the civil court. There is a bar under section 12 of the OPP Act, my lord. I cannot approach the civil court. Section 14 is a bar, my lord.
No. That is not the finding of the Honorable Single Judge. Honorable Single Judge has said that you are at liberty to approach the civil court for necessary relief.
No, my lord.
If you are prejudiced by the OPP order, then you can seek injunction and saying that I am not covered under the OPP Act. Because I am a tenant of the possession. Section 8(1) of the OE Act protects my possession. So in that way, you can ask for injunction before the, not that the Honorable Court has.
Unless and until the order is set aside.
Approach according to my respectful submission, that
unless
the Honorable Single Judge has rightly directed him to approach the civil court. If
He's already filed a civil suit.
He
already
has already
filed.
filed.
My lord, I have filed. I have filed.
The suit is pending.
My lord, suit is pending for declaration of my title, occupancy lawyer. My lord, during the pendency of the suit,
you take an interim order.
My lord, that is what I am taking order. But so far as the order of OPP court is concerned, my lord, that has to be decided. Unless that order is set aside, my lord, they will proceed under the OPP Act, my lord.
Yes.
So, my lord, I pray, my lord, next week I'll advance the argument with all the, my lord, citations and all these things. Your lordship,
merits, what is?
My lord, on merit, I'll argue, my lord. I am not ready, my lord, today. My lord, I pray only, my lord, 7 days time, my lord. Next week, any day, my lord. Any day next week, my lord. My lord, may keep it to 3rd of May, my lord.
No, I think it's perfectly all right. The order is perfectly all right.
My lord, your lordship may kindly see
Perfectly all
the order of the Honorable Single Judge. The Honorable Single Judge has said, my lord, you approach the civil court.
Correct.
My lord, I cannot challenge the order of the OPP court before the civil court, my lord.
No, that court, sir.
That is not the approach of the Honorable Single Judge.
Honorable
and unless, my lord, my humble submission.
All these proceedings under the OPP Act, you are entitled to claim injunction or ask for injunction before the civil court. If your
my lord may, in that case, my lord may clarify that despite order of the OPP court for eviction,
consider it independent.
My lord, your lordship may clarify
On
that.
its merits, it has to be considered, sir.
My lord, yes, my lord, your lordship may clarify that
The
unless
president had approached the Lord Single Judge, agreed by the orders passed by the estate officer or
Director of Estate.
2110/2022 in OPP case number 6/2018 under sections 5(1) of the Orissa Public Premises Eviction of Unauthorized Occupants Act 1972 and the subsequent order dated
7/2/230.
7/2/23.
No, my lord.
1 minute. Don't interfere, sir. Don't interfere. Subsequent order dated 7/12/2022 passed by the Director of Estates rejecting OPP appeal case number 61/2022 paragraph. The learned single judge has noted that during the pendency of the proceedings under the OPP Act, the appellant had instituted CS number 41 of 2018 in the Court of the Civil Judge Senior Division, Bhubaneswar, seeking declaration of his title in respect of the property in question. Along with the said, in the said suit, he had also filed IA number 1 of 2018, in which initially the status quo order was passed by the civil judge, which then stood vacated by the court by an order dated 1st August 2022. Sorry, no, you say initially a status quo order was passed on 1st August 2022 by the learned civil judge senior division, which later stood recalled, stood vacated. Full stop. Apparently, the appellant had filed a subsequent application for recall of that order.
My lord, that order has recalled, my lord. During the pendency of the appeal, that order has been recalled.
And then your status quo is continuing.
Status quo is continuing.
Mr. Raut informs the court that the said order dated 1st August 2022 has since been recalled and the status quo has been restored. Paragraph. The learned single judge has, after noting the above, of the pendency of the above suit, observed in the impugned order that the appellant is at liberty to approach the civil court in question, open quotation, bringing to its notice about any action taken in the meantime, comma, which caused prejudice to the petitioner, comma, so that the same can be considered and appropriate orders can be passed in accordance with law. Quote. Paragraph. In the considered view of the court, the above direction was the only one that could have been issued in the facts and circumstances of the case. Full stop. Consequently, the court finds no ground made out for interference. The appeal is dismissed.
Item number 88. Lord, item 88 state is the appellant. By the impugned judgment, the Honorable Single Judge has directed payment of ex gratia of rupees 4 lakhs in favor of a kith and kin of a deceased who allegedly died. According to the case of the petitioner, he died in Phani due to collapse of wall, that is cyclone, Phani cyclone. I will only draw your lordship's attention to the page 44 of the appeal memo, annexure D/4 to the counter affidavit which was filed by the state before the Honorable Single Judge. That is page 44 of the appeal memo. This is the inquiry report of the collector Noyagad submitted to the Joint Relief Commissioner so far as the death of the deceased is concerned. It is clearly found that there was no evidence of support of theory of cross injury, heading or death. The cause of cardiac respiratory failure could be stated after forensic analysis of the viscera. The viscera of the deceased has been preserved by the doctor, and the viscera report is also that it is not due to the collapse of the wall. There is no injury in the post-mortem report. And we have placed materials before the Honorable Single Judge to show that the deceased...
All right. You say notice returnable. 1st August. There shall be stay of the impugned order. All right.
Item number 89.
And in this case, my lord, just a minute. In this case, they have made a unanimity the proper opposite party. The state has made a unanimity the proper opposite party. Mr. Mohanty is mentioning the hearing.
Oh, in this case, they are the proper opposite party. Their appearance may be rotated.
Not on my appearance, I need a copy from them that it will be.
No relief is sought for against. We have to pay the. We will give. We will give.
All right.
89.
89 rehabilitation 30th August.
Notice 30th August.
Item 90.
My work 14th September 1991 same.
92.
My lord, state is the appellant. the revisional order was challenged under the Consolidation Act. The the order was challenged by one private party against another private party. The Honorable Single Judge has held that it is the land of the government, it should be recorded in the government khata. And Commissioner has held. Against that, the aggrieved party has preferred writ petition. And the Honorable Single Judge has said that it is unsustainable. Government is not a party to the litigation, so no land should be recorded in favor of. But it is a government land, and your Lordship may kindly see the impugned order at page 43, para 6. Considering the rival contention of the party, this court finds there is no denial by the parties involved that the revision exercise was undertaken by the Commissioner under the provisions of Section 36 of the Act, Section 30. Reading through the provisions of Section 36 of the Act, this court finds the proceeding under Section 30 is an intra-party dispute. It is up to the revisional authority based on its own calculation either to allow the revision or dismiss the same. But in no circumstance, the Commission can exercise its power available under Section 37 while conducting a case under Section 36. This court here further finds, in the event the revisional authority comes to observe that there is an involvement of third-party case, nothing prevented the third party means government. Nothing prevented the Commissioner Counsel to ask the party to involve each party and decide the matter in terms of Section 37 of the full by giving full opportunity to parties likely to be affected, and in absence of which this court finds that the revisional authority has exercised its jurisdiction beyond the provisions of. In this order, this court interferes with the part of the impugned order of the Commissioner, directing the Tahsildar to prepare the ROR, set aside the same revisional order for dismissal of the revision. So, the Commissioner found that it is a government land and directly Tahsildar. The Honorable Court's view is that government was not a party in the revisional case. Before the Commissioner, government is not a party under Section 36, proceeding under Section 36 of the Act. So this direction is uncalled for in absence of the government as a party. My respectful submission, your Lordship may see.
No counter was filed.
No counter was filed.
But then matter was pending for 6 years.
This is a recently filed appeal.
No, appeal is filed now, sir.
Yes.
Writ petition was pending for almost 6 years.
Yes.
You could have easily filed a counter.
It is, your Lordship may kindly imagine, this is the same case where the parties are claiming that Aikpadiya and Hathapatta of unregistered Hathapatta, they are claiming title. The Commissioner took note of all these facts and came to a conclusion, no, this land cannot be recorded in favor of any of the private party. It should be recorded in favor of the
notice
state.
Returnable 2nd August. There shall be stay of impugned order.
93.
90. Notice on delay.
93 में शर्त पड़ा 8th में.
Notice written.
94.
38, my lord. Rehabilitation assistance.
All right.
95.
Well, 95, it is reported that there is some delay, but I don't think there is delay. But the office note says there is some delay. I'll check up and file an application for condonation of delay.
$21 days. All right. List on 1st August. Effective your time. All right.
Item number 96.
96, my lord, infructuous matter.
Infructuous.
Appeared for the below 5.
All right.
Item number 97.
97, may I please, lord, state has to file the compliance of affidavit, your lordship.
My lord, kindly give this past date of filing. And,
all right.
Inquiry is going on.
Seeks some more time. File a comprehensive affidavit. This inquiry took place or not?
Yes, your lordship.
Already taken. The report is to be submitted. 15 days time.
You see, Mr. Mohanty submits that an inquiry has already been undertaken.
I can't submit that whether it is completed, but I know that inquiry is going on.
Yeah, that an inquiry by the CDMO, Jajpur,
has already taken place pursuant to the order of this.
And a report, comprehensive report is awaited.
Yes.
it be placed with an affidavit before this court positively before the next date. List on 28th June, sir.
28th June. Obliged.
Obliged.
Item 98.
May I please, my lord. In this case, the appeal is directed against the order of the Honorable Single Judge, wherein on the very first day, Honorable Single Judge, without issuing notice to the appellant bank, disposed of the writ application with a direction that they should be regularized, and then again a further direction to consider, my lord. Paragraph page 26, my lord, the impugn order. Para 5, there is a positive direction, and then again para 6, it has to be considered. Page 26, my lord, of the impugned order. Of the running page 26, internal page 2, impugned order.
It's coming up after notice. So
yes, ma'am. Yes, ma'am. Respondent earlier occasion time to file counter affidavit.
I'm appearing for the private respondents on behalf of Mr. Rathamala. I'm listening.
So let it go back, sir. Again, very first day without notice to them.
Lordship would see in the writ application, these people have worked for more than a decade, my lord, and
that's all right, but you should have an opportunity to at least file a reply. They're not even heard. Very first day it's disposed of. You say the main relief, the impugned order, has been granted against the present appellant, to whom not even notice was issued by the learned single judge. Full stop. The writ petition was disposed of on the very first day of the listing of the petition. Full stop. Only the additional government advocate representing respondent one.
It was not a party. It was not a party. In fact, perhaps it wrongly.
Only the appearance of the additional government advocate is indicated. Although the state of Orissa was not even a party. Full stop. For the aforementioned reasons, the impugned order is hereby set aside and writ petition civil. Two 8350 of 2021 is restored to the file of the learned single judge in the roster bench, where it will be listed for hearing on 18th May 2023. The learned single judge is requested to proceed with the petition afresh in accordance with law. Afresh. Yeah. And if the petition is to be entertained only after notice to all the contesting responses. The appellant herein will appear before the learned single judge on the aforementioned date. All right.
Item 99.
We have the opinion number 32. They have implemented the opinion number 32 in this case.
All right.
Item 99.
99, Your Lordship, this is a DLA matter regulation. The similar matter has already been posted to 25th of September, Your Lordship.
All right.
No. May I make a prayer, my lords?
Let me.
Okay. You start.
In 99, some matters are different that has been, Your Lordship may find it from WA 82 of 2022. This matter can be fixed to 14.7.
No, let's go one by one, sir.
Yes.
Sub-item 1, writ appeal 3.
That is 25.9.
So list on 25.9. Then writ appeal 4.
25.9. 5, 6, 8, 11, 13, 67, 68, 25.9.
25.9. Up to 68.
82 of 2022, 14 September, July.
Sorry, 82 of 2022 is?
14th July.
14 July.
Ma'am.
All right, list on 14 July.
Then 104, 25.9. 105, 25.9. 180, 25.9.
180 minutes, it is a first day disposal, my lords. Let the matter be remitted back to the Honorable Single Judge, my lords. There is some requirement for counter is necessary, my lords.
In 180, you say it is seen that the impugn order was passed on the very first day without an opportunity to the appellant to file any reply. On that ground, set aside, it will now be listed before the single judge in the roster bench on 4th September. The appellant will file its para-wise reply on or before 21st August. And the respondent petitioner will file a rejoinder, if any, thereto on or before 4th September. No further time will be granted to either party for that purpose. The learned single judge is requested to proceed with the hearing on merits and dispose of the writ petitioner's expectations if possible.
Till such status quo is respected.
Till such time status quo shall be maintained.
Yes, grateful, my lords.
The writ appeal is disposed of in the above terms.
Grateful, my lords.
Then
190.
190 outsourcing 8th August.
Yes.
8th August.
192 14th July.
No, 192 also first day disposal. Let this matter be remitted. Same order as in
all right.
180.
192 was the same.
Only that status quo part may not be reflected in this matter because the petitioner is the respondent is not containing matters.
All right. 192 no status quo, but otherwise same order.
Yes.
193.
193 my lords, 8th August.
193 and 194 8th August.
8th August. All right.
Yes.
All right.
For hearing item 100.
May I make a prayer, my lords? May I make a prayer? There's 3 cases, my lords, which are directly covered by your lordship's order in Patita Pavan Datta Das.
You mention it in the morning tomorrow.
But that it has been wrongly posted to 8th of August, my lords. And make a mention.
Morning you mention it so that he'll know.
Give me copy.
I'll give the number to you today.
Item number 100.
May please your lordship, I am in a distant mode. If your lordship would permit me.
So shall we have it after the vacation, sir?
But after Jagannath Basti, petitioner in person, appeared in from the Puri minor. I'm the petitioner in WPC number.
Right. Have they filed now all the replies? Everything is over.
That is pleadings completed.
My lord, several directions of the Honorable High Court.
My lord, the main matter is filed by Mr. Acharya Senior.
No, that 11968 of 2020. They've not filed a reply till date. This IA,
that amendment.
Mr. Basti has
amendment. That is the same prayer. Both the intention of filing this writ petition, both the petitioners same. So
no, that 11968 is an IA, sir.
I will file.
Let this issue, may I submit for a minute?
Yes.
This is a very serious issue.
Right.
The properties of Lord Jagannath under Amrut Manohi's status, the procedure, etc., to be dealt with, are already crystallized in Siddhamatha case. So therefore, it requires, the hearing. The lordship is right if it can be taken up after vacation any day. So because there are lots of parties, I think, a dozen of lawyers have already appeared. So it may take time. So the interim protection is also there. Your lordship may explain.
No, there is no interim order. There is no interim order. You can verify.
Render the writ petition infructuous. It is already there.
There is no interim order. And they have tried for interim order and your lordship has rejected it.
No, there is an order.
If your lordship will permit me, I will submit a few words before your lordship.
No, I am for the petitioner. If you want,
you complete your argument, then I will submit.
No, that's
you complete your argument.
I am for the petitioner. If it is for hearing, then I have to address the court.
No, I am not hearing. I am not placing the matter on merit. I will only make a small submission before your lordship.
The state is prepared for hearing, beloved. I am prepared for hearing today evening. Sure.
Your lordship can fix it to after vacation any date at 2 p.m. I have absolutely no objection to that. If your lordship will permit me, I will only place only one word before your lordship. Both the cases are interlinked and same relief is prayed for by both of them.
My lord, of both the allegation and the prayer of Dr. Samit Patra and me in my case is totally different, my lord. So I pray, my lord, kindly
direct. But cause of action is the same. You may be praying for some other things which is additionally what is prayed for in the first writ petition, but cause of action is the same. If your lordship will see, The prayer in the main writ petition filed by Mr. Acharya, senior advocate, prayer number B, he has specifically prayed for correction of a record of right, HAL settlement record of right, in respect of the suit land, which was published in 1990 by the settlement authority in accordance with law.
If my learned friend is addressing on merit, then let me begin. I have a
No, you have also said many things, so should I not
no, that's
submit?
correct. So therefore,
It's
I am
okay, it's okay. Your lordship may fix it
prepared
to
for
any
hearing.
date.
Let us proceed. Let I am prepared for hearing, final hearing.
Your lordship may fix it to reopening date at 2 p.m.
I pray, my lord, really issue direction to the state government and the other opposite parties to file the counter affidavit in my amendment petition. File miscase number of
Correct. That's what. So take a separate order. This IA number 11968 of 2020 in WP Civil 23988 of 2019. Despite time having been given on 22nd June 2022 to the state government to file a reply to this application, more time is sought today. Last opportunity is granted to the state government to file a reply to this application on or before 1st July 2023, and rejoinder thereto if any be filed by the petitioner appears in person before the next date. Then you see in the other matter, list along with this writ petition civil 23988 2019 on.
Let a date may be given so that at 2 p.m. I suggest.
1st August, sir.
My lord, it may be in July, my lord. I humbly pray for your
all dates in July are taken up. That's why.
No, any date, July, it will take only half an hour. Your lordship may see this.
This one,
not
you can
less.
Take it from me, it will take 2 days.
No, it will never.
Your side maybe half an hour.
The kind of
no, absolutely not. Your lordship, see, your lordship can dispose it off within half. Your lordship may fix it to third week of July. Third week of July.
Any date.
That is my humble prayer before your lordship. Third week of July.
No, sir. All dates there is something.
My lord, any day, we can be accommodated at 2 p.m. or at 10:30.
1st August.
Your lordship may fix it to any
day. Third week of July and 1st August makes no difference.
Both the matters are 1st August.
1st August. All right.
Passed on matter item number 21.
May I please, your lordships? My lord, your lordship may come to page 46.
Yes.
This order was challenged before Honorable Single Judge, your lordship.
Yes.
The grievance was there, my lord, without giving opportunity of hearing to the petitioners, who are the mother village, or it is relating to the bifurcation of the village. The mother villagers, my lord, this order was passed by the Director of Land Records. It is also the law is well settled in 2006 to OLR 817 and 2002 OLR 177. The Honorable Single Judge, your lordships, was pleased to issue notice, but the interim order is passed, my lord, it is subject to the result of the writ application. My humble submission,
sir, that's the usual order.
Your lordship may kindly see, visualize one thing, appreciate one thing. But if the proceeding will be proceeded with, ROR will be published and everything will be done, and it will be very difficult to return back again,
sir.
My lord, in respect of a village, it is relating to the bifurcation of the village. My lord, more than 2,000 people are there. My lord, if ROR will be published like that, my lord, again, my lord, if I will succeed in the writ application.
Anyway, this is 2 years since this order was passed.
My lord.
What has happened in the meantime?
It had come before lordships earlier. It had come before lordships.
No. What has happened? We have not passed any stay order.
No.
So by now they must have published.
My lord.
They published.
My lord, I had no instruction.
You see,
but the Tahsil, I have instructed that
directed against an interim order.
Tahsil has proceeded with your lordship.
All right. The present appeal is directed against an interim order dated 4 July 2021 in WP Civil 16005/2021. Full stop. All that the interim order does is that to clarify that any development during the pendency of the writ petition would be subject to the result of the writ petition. Stop. The court sees no ground made out for interference with such an interim order. The writ appeal is accordingly dismissed. This writ petition lists before the roster bench.
There are two writ appeals
on 18 July.
Item number 40.
Your Lordship, before vacation, the writ application may be
Item number,
before vacation, my lord, the writ application may be posted.
No, that's right.
my lord, item number 40, this is a gross case wherein, my lord, the learned single judge has not taken into consideration, my lord, all the averments that was being taken by filing a counter affidavit. Not a single word has been reflected, and has directed that the order to my lord will be in accordance with the earlier orders which were being passed, which was on a different factual matrix. What has happened in this case, my lord? The respondent was working in the Bhubaneswar Municipal Corporation. She was being given a quarter. Now that was a slum quarter. She comes before this honorable court saying that is slum quarter to be settled in favor of him, my lord.
All right, notice returnable. And notice on the stay also. There's no contempt, right?
My lord, there's no contempt now.
So notice on that stay also, returnable 2nd August. All right. Yeah,
Special list.
yeah. In all these matters, you see these contempt petitions are closed.
Closed.
Yeah, with liberty to the parties who may be aggrieved by non-implementation of the orders to file appropriate applications in accordance with laws. Right.
Supplemental list, fresh admission, item number 1, CRLMC 851 of 2020.
None appears dismissed.
Item number 2, CRLMC 870 of 2020.
None appears dismissed.
Item number 3,
Same order.
item number 4,
Item 4, my lord, trial is continuing.
So permitting you to take all pleas.
Yes.
Permitting the petitioner to raise all the appropriate stage. All right.
item number 5,
Your Lordship, item 3, Your Lordship. Item 3, Your Lordship. The matter was compromised between the informant and the petitioner, Your Lordship. Already has paid the 91 lakhs, already paid, Your Lordship.
You pointed out to the trial court, sir.
Matter was
Permitting
compromised between the parties in
Yeah,
the
let them be called there, sir. You may have to file the affidavit of that party. You see,
Already, Your Lordship, I have filed the money receipts also filed.
you pointed to the trial court, sir, permitting the petitioner to raise all pleas in the appropriate stage in the trial court. Petition is disposed. All right.
item number 5,
None appears dismissed.
item number 6,
Same order.
item number 7,
Same order.
item number 8,
Same order.
item number 9,
Same order.
item number 10,
Item number 10. My lord, in earlier occasion, my lord, please to call for the obtained case CD.
No, only last time nobody appeared, so it's got adjourned. The informant has filed an affidavit. What does the informant say? This is CRLMC 1031.
No, my lord. CRLMC 947 2020, my lord.
Oh.
Item number 10.
You were to obtain the case diary, what happened, sir?
Yes, my lord, in this case, my lord, final form has been submitted, my lord.
I see.
Then after I'm challenging the cognizance order.
But if charge sheet has been filed now, you know the next stage, sir. No need to interfere now. You say permitting the petitioner to raise all pleas at the appropriate stage. All right.
Item number 11.
This is what you see. All right, none of is dismissed.
Item number 12.
Same order.
Item number 13.
Still, my lord, 1 week time, my lord. File not press out, so 1 week time.
No, 1 minute. What is the matter about? Cognizance. Permit you to take all pleas. Permitting the petitioner to raise all pleas. The appropriate stage. The petitioner.
Item number 14.
14, my lord. In this case, the connected matters are already listed before the Honorable Court number 5, and the vigilance has already batch case.
Huh? No.
It's a
5 means food.
Already in the list, batch case, my lord, the connected letter.
It's not a batch case, my lord. It's a
It has
criminal
been-
case, and this case is different from others. It's relating to particular case.
No, but
Oh, I see.
the vigilance has
And
filed
yes,
one
and the
objection, my
FIR.
lord. One objection has been filed, showing that it will be adopted in all other cases.
That is in respect
the
of
true,
that
my lord.
batch case.
That is the batch.
So far as this case is concerned, he has challenged the FIR. We are
All
able to proceed.
All are similar. All are similar. You have filed one objection and saying that it will be adopted in all the cases. It is not the out of that FIR. It is all the and the matter is already in the list.
Same FIR. Different FIR.
Different cause of action is same, and all their MDs are all are. And you have filed one objection saying that it will be adopted in all cases.
And
now
similar issue has already been decided in another case.
Not in our
the present petition number 2, another FIR was there, and it was decided by the Honorable this court, and this court was not inclined to interfere.
No, that is not our case, my lord.
Your lordship
You don't know
decided
that in the
that
case.
very
What is
case
the
also.
ground deciding?
What is the ground you're making out? Let's see. Why do
Ground, my lord, what is that? The petitioner was working as a managing director of the cooperative society. So there was the government
paddy procurement
interest that to procurement of the paddy. So they have alleged that they have excess expenditure towards Mondi laborers. Because
why at the FIR stage we should interfere?
No, I'm just coming, my lord.
Let
The
it
Mondi
continue.
labor, my lord, what happened, my lord?
Charge sheet not filed yet.
Charge sheet not filed. And the question is, my lord, they have already surcharge proceeding has been initiated against the petitioner for recovery. So there is no criminal case because excess expenditure. They have stated that excess expenditure towards the Mondi labor charges amounts to misappropriation. So my response is how if I will excess expenditure there because the expenditure has been made by the approval of the government, and government subsequently withdrawn that approval letter. So that's why
that has to be examined by the trial court, sir. We can't.
So that's why, my lord, we have already the batch case, and it will be decided in that case in court number 5. It is already
raise all pleas at the appropriate.
And charge sheet has not been filed. So how the trial court? Because now my question is the charge sheet has not been filed. It is under the investigation.
Correct.
So I have filed for the questioning of the FIR, my lord.
Not necessary, sir.
Then
permitting the petitioner to raise all pleas at the appropriate.
Then, my lord, I am permitted to withdraw, my lord.
All right. Counsel for the
with the liberty to file a better petition.
No. Permitting the petitioner to raise all pleas at the appropriate stage.
Permitted to withdraw.
No, we're not permitting to withdraw. Permitting you to raise all pleas at the appropriate stage. All right.
No, because now is not case. No, because what happened, my lord?
No, several rounds.
So only investigation is going on.
Sorry, sir.
Since last 5 years. So no charge sheet has been filed.
All right.
Item number 15.
None of this.
Item number 16.
May I please, your lordship? My lord, here the petitioners challenge the order of the executive magistrate, where he deprived them from availing the documents which are part of the record. My lord, have a glance on annexure.
There's no stay here. That's all infructuous, the passage of time. Nothing remains. We say this is a proceeding before the executive magistrate, which on account of the passage of time would have been rendered infructuous by now. Under section 107 CRPC, which the passage of time has been rendered infructuous. The petition is accordingly disposed.
My lord, in the meantime, the 6 months time has already been lapsed.
That's why I said precisely. That's what I've dictated. Passage of time. This is all infructuous. Yes.
Item number 17.
17 and 18 permitted to file a better application. Cognizance order has not been had by
Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed. Right.
to file a better application, my lord.
No.
Order of
Second round, third round of this. Yes.
Item 19.
Yes.
May I please, your lordship?
Yes.
Well, here in this case, my lord, the petitioner has prepared this petition praying for quashing the criminal proceeding, my lord.
Yes.
My lord, alleged offences are under section 498A, 302, 304B, 201 by 34 5PC,
right.
Reduce section 4 of DP Act, my lord.
Right.
My lord, kindly have a glance at Annex 1,
yes.
page 10, my lord.
Yes.
My lord, FIR has been registered
yes.
by the father of the deceased, my lord, Rohin Meher, my lord, against Prakash Meher, who is the husband of Rohin Meher, and Minno Ketan Meher is the father-in-law, and Subhashini Meher is the mother-in-law, my lord.
Yes.
My lord, but after completion of investigation, charge sheet has been submitted against 9 accused persons, including the present petitioner, and 6 accused persons were shown absconded in charge sheet, my lord. The petitioner is one of them, my lord. And my lord, thereafter, my lord, 7 accused persons, my lord, after the case was split up against the present petitioner and one Vinod Meher, my lord, 7 accused persons faced trial, and they have been acquitted, my lord, by the learned court below, my lord.
Then it becomes easier for you now. It becomes easier for you. It becomes much easier for you. Appear in one day before the trial court. You're absconding right now.
My lord, in the meanwhile, NBW has been issued against the present.
Correct. You want to do a shortcut, basically. Come in a 482, get it all stayed. Better still, get it quashed.
My lord, my small prayer, my before my lordship, that the present NBW may be quashed and he may be directed to surrender or release on bail.
Not quashed. We'll just stay till the date you appear.
At least the allegation within the forfeit 201, my lord.
1 minute. Where is this court's Sambalpur?
My lord.
The petitioner will appear before the learned ADJ presiding officer, OPID Sambalpur. In PS case number, in ST case number 51/26/18 of 2011/2022, arising out of CT case number 1103 of 2007, relating to Qatar Baga, PS case number 130 of 2007, on 8 May 2023, till such time the NBW issued against the petitioner will not be executed. But stay will end on that day. Thereafter, it will be open to the petitioner to seek appropriate directions from the trial court.
Item number 20.
Pardon me, my lord. Pardon me, my lord. Item number 15, my lord. Just pass away. Sorry, my lord. Item number 15, I am informant, my lord.
Yes.
In this case, both parties are amicable settlement, my lord. This is my Boklatnama. I am informant also. Item 15.
All right. You say counsel for the...
May I please, lordship? I am the petitioner in this case, lordship.
Counsel for the
323, 354B, 352B. Lordship already compromised the...
And confirms the affidavit dated 3rd March 2023, filed by the informant, stating that the disputes between her and the petitioners have already been resolved. That view of the matter, take the prayer clause and all proceedings consequent that will hereby. All right.
Item number 20.
The petitioner is the complainant in the trial court in a Narrative Instrument Act. After taking cognizance and the petitioners are already adducing evidence, all these things, the criminal division filed before this honorable court. In the bunch of criminal division filed by the opposite party number 2, who in a one criminal division, it has been distinguished all the things and directed to bunch all the case should be transferred to the JMFC body. As per the order of this honorable court in the criminal divisions, and my criminal division is also there, by which is filed by the opposite party number 2. The learned court that Rahul Kela has already permitted to withdraw as per the order of this honorable court, and I have withdrawn the document keeping the record in one copy. But while as per the honorable court, I am filing the same court's body bill, it has not been registered. He has refused to register the reason I don't know. But the order is, my lord, so in Annexure 4, that is, my lord, in page number 1111, and my lord, so that my lord, so 1111, in paragraph 19, that in the result of the carefully conspicuous entire materials, records, as well as law-knowing field of regimes, the the governing field, this court of this opinion, the cognizance of reported by the SDMC Pan Post. But my case is the SDMC Rahul Kela. And the provision of Company Act, representative court fees or act of jurisdiction. But my case is not the depository of court fees. However, this the complainant before the SDM Pan Post are allowed to withdraw the complaint.
Which is the order you aggrieved by?
My lord,
what are you aggrieved by? Which is the order you are aggrieved by?
My lord, he's not registering my complaint.
Who is he, sir? What is that he? Which court is not registering what complaint? Tell me again.
My complaint petition, which is has been transferred from the Rahul Kela, is not being registered. Where I may go?
No, not being registered by whom, sir?
My lord, JMFC bought bill.
Where is that order?
That my lord, is not being registered. If he is registered, he is passing the order. If he is not registered, then
when did you file? You must have filed some memo or something.
Yes, my lord, I have filed Annexure 5 series.
Annexure 5 series. All right.
The first is that accept the transport case records. 114 and 115 is the order of the JMFC Rahul Kela.
All right. The grievance of the petitioner is that the JMFC Barbell is not registering the complaint of the petitioner under section 138 of the NI Act, which has been transferred to that court pursuant to an order passed by the learned single judge of this court on 7/7/2021 in
criminal division of 307 of 2000.
In criminal division 307.
307. It is in that batch of case. I pointed to my notes.
307.
307 of
2011. 14.
Yes, ma'am.
Or 11.
No, it's 14. It is in the page number 81.
2014 paragraph. A report be called for from the JMFC Barbell. In this regard, before the next week. Before the roster bench. On 9th May. A copy of the order be sent forthwith to the JMFC Barbell. All right.
Item number 21. Item 21.
None appears dismissed.
Item number 22.
None appears dismissed.
Item number 23.
May I please? My lord, the petitioner before lordships for quashing of the criminal proceeding in GR case number 421/15 initiated against them on the ground that the OP2 is not the wife of the present petitioner. My lord, the OP2 had married in 11/4/1992 to one Dilip Kumar Sahu in 1992. And in 2011, sorry, my lord, in 2010, see, the OP2 initiated a maintenance case against that Dilip Kumar.
So has cognizance been taken?
Pardon, my lord.
Has cognizance been taken?
My lord,
charge sheet has also been filed.
My lord,
charge sheet has already been filed.
My lord, my case is that while, my lord, what the section says, well, 498 says.
It, sir? Charge sheet was filed way back in 3/11/2015. Give us the date.
My lord,
give me the date. What date was charge sheet filed?
3/11/15, my lord.
So what has happened since then, sir?
My lord, I'll take instruction.
What is instruction? This is the first date you filed.
My lord, for appearance, my lord, for appearance of the bill.
for appearance of the petitioner, my lord.
What for appearance of petitioner?
Before the law and court below. Case has been posted for appearance, my lord.
So that's it.
My lord, while the offences are not attracting against the present petitioner, she is not the legal married wife, and she has a husband.
Yes.
And there is, my lord, kindly peruse, my lord, annexure 3, my lord.
Correct.
For a second.
All right.
Annexure 3. 3 so also, my lord, annexure 4.
Yes.
My lord, so annexure 4, my lord, page 37, the mad case, my lord. Divorce was allowed between the OP number 2 and Sir Dilip Kumar Pal. While there is a dispute between the OP2 and her husband regarding maintenance case and divorce case, how, my lord, 490 day will attract against me, my lord?
Where is the order against which you are coming here?
My lord, I have come to against the quashing of the criminal proceeding, my lord.
No, can't generally come, sir. There must be some development in that criminal proceeding. What is the order? There's a charge sheet filed in 3rd November itself. Why have you come so late? What has happened in the meanwhile?
Everything I have mentioned in this petition, my lord, kindly permit me one. My lord, para 9 of my petition.
Yes.
I had come in CRNC number 2995/2016, my lord. In that case, this honorable court
That's the whole problem. It was dismissed for non-prosecution. Why you're telling me now?
No, my lord. I have everything I have exposed in the.
It doesn't mean you file a separate petition again, sir. You have to do something about the dismissal of that petition. You can't have a second 482. You allowed the first one to go for non-prosecution.
My lord, in that case, there is a separate advocate, my lord. And
can't be helped. What do you want to do? You want to withdraw this? Or I'll have to mention all this and dismiss this now. The choice is yours.
I pray one thing, my lord. If I will file a 205 petition, that can be allowed.
No. All that you know, sir. I don't have to observe all that here. The president
permitted to withdraw.
Counsel of the petition seeks leave to withdraw this petition. Dismiss this withdrawal. All right.
Item 24.
24. None appears dismissed.
Item number 25.
Same order.
Item number 26.
Item number 26 on behalf of Durga Prasad Dhara. Let it come next week, my lord. Some personal difficulties today.
Counsel of the petitioner is stated to be in some personal difficulty.
Obliged.
On 15th May.
Item 27.
Please, my lord. My lord, petitioner's prayer is for washing of the city case number 5 to 6, pending in the Komna PS, pending in the before the JMFC, Nuapada. The FIR allegation, my lord, FIR, my lord, in page 13. FIR is written to the Superintendent of Police, Nuapada. The subject is siphoning of rehabilitation and resettlement assistance of displaced persons affected
Mr.
the
Mishra.
Lower Indravati Irrigation Project, Khariar.
You are Mr. Mishra?
Pardon?
Are you Mr. Mishra?
Yeah.
Sir, this is a 2013 case.
My lord.
We are in 2023.
Yeah.
In the 10 years, charge sheet has already been filed.
Yes. In 2014, it was filed.
14, it was filed. 9 years, what has happened, sir?
Nothing has happened and I have never been noticed. I was Tahsildar elsewhere. I was different.
Then why are you worried, sir? Why are you worried? Why are you unnecessarily, now today I'm going to say that the proceedings have to be expedited. So the benefit you will get coming to this court is proceedings will now get expedited against you. Are you happy about that? You're happy?
That I have not.
You're not happy.
I have never got any.
You don't want proceedings to go on.
My lord.
Proceedings have not gone on for 10 years. Now you don't want it to go on at all.
It is only pending in the JMFC before the JMFC in Nuapada. I have never been noticed, never been.
So now should we ask them to do all that? If so desire, I can say that why have you not? I can pull them up saying, why are you sleeping on a case? This is a 13 Prevention of Corruption Act case, correct? Must be a PC Act case.
My lord, I may be permitted.
No, this is a PC Act case. Final form.
No. 419,
468, 471. We can ask this entire thing to be expedited. Will that help you, sir? Will it help you?
My lord, this is
your client is anxious that something should happen in the case.
My lord, this is totally a false case. And
that's right. So your client is anxious that something should happen in this case, correct?
The anxiety, after knowing all these things, anxiety must be there. But
we can ask them to expedite everything now. Despite charge sheet being filed, nothing is happening according to you.
But
in a case of such grave charges, 468, 471, all grave charges.
It is only in the case file. He has never been informed of all these things, all these years.
We'll ask him to
expedite. And he was the project head of that project.
We will say you are very concerned that nothing is happening in your case. So we'll ask them to expedite the proceedings.
But these sections are cognizable sections and
correct and all cognizable. And you have not even been arrested. Till date you've been arrested or not even that? Nothing.
Nothing.
Look at the sad commentaries, sir. Cognizable offenses last 10 years, not even arrested. And he's absolutely concerned. How come you're not even arresting me? What do you want to do, sir? We can pass orders for them to actually enforce the rule of law.
My lord, the case has no prima facie at all. And it is,
that you realize 10 years later.
I have never been informed.
That's what.
My lord, I may be permitted to bring all the court papers from there.
Permitting the petitioner to raise all pleas at the appropriate stage, the trial court. The petitioner is supposed to.
Item 28.
So you better make a note of these things.
Yes,
another 3 months later, another petition will emerge through another counsel who will not tell the court or you that this has already happened.
My lord,
you can take it from me. This is regularly happening. This is like forum shopping. 482 can't succeed before this court. Keep quiet. 6 months later, one more 482.
My lord, I may permitted to withdraw.
Not necessary. This order is good enough. Yes.
Item number 28.
On behalf of Das, my lord, may I please your lordship. The petitioner not named in FIR filing this application for cost of the criminal proceeding, and not as far as the injury is concerned, no significant injury is found in the injury report, my lord. Page 9 and 11, your lordship kindly see. And all other co-accused persons already released on bail who named in the FIR, my lord.
Bail and all is different, so don't mix up bail with this.
Your lordship directed to surrender and expedite on the same day and maintaining parity, my lord.
This is only for quashing. What have you challenged here?
My lord?
Only quashing you've challenged, not NBW.
No, I'm quashing.
That's all.
Quashing of FIR. So I intend to surrender.
In these fresh matters, you reproduce a prayer clause and then say permitting the petition. For your benefit, sir, the prayer clause is being extracted because it will have the PS number, CT case number, everything. Yes. You should know that somebody like this came and this order was passed.
I pray, my lord, I surrender and maintaining parity, both the court dispose.
That's not even the subject matter here, sir. Subject matter here is simply quashing. That's it.
As because
29.
I not intend to quash the FIR, I permitted to surrender before the court below, my lord.
All right.
29.
My lords, 29 pass over, my lords.
All right.
Item number 30.
In 30, my lord, that is a quarrel between the two students groups. And in CRLMC, this order has been passed by this court just to surrender and move for bail on the same day, parity, my lord. This order is on the, as far as the co-accused person is concerned, my lord.
This is not 482 is not for all this, sir.
My lord, this is already observed by this. I am not asking for a.
You should go by the prayer. What prayer you're making? Ultimately, it has to have a relation to the prayer you've made.
IA is there, my lord.
Where is IA?
My lord. Or a lordship directed to surrender and maintaining parity, dispose of my bail application on merit, my lord. As far as the co-accused person is concerned. A 19-year boy, students are studying in the college. There is a dispute between the two students.
What is the connection between this one for 4?
Same PSGR, my lord. Same case. Same PS, same GR, my lord. That is the why I am giving the copy of this order of this honorable court, my lord.
JMFC to Cuttack.
Same case.
No, but there's no GR number and all here.
Yeah, this honorable court directed to surrender and move for bail.
This is also 2, is it?
As far as the other co-accused person is concerned.
All right. Same order. All right, same order. Okay.
Oblige, ma'am.
Item 31.
My lord, Mr. Sahu is ill, my lord, kindly taken in.
All right. Counsel, the petitioner is unwell. List on 9th May, the roster bench.
Item 32.
32 on behalf of Das, my lord, may I pleasure. Offense under section 379. The allegation is that a stolen of one hammer and 5,000 rupees. I am not named in affair. I am implicated in this case on the basis of confession of co-accused. I pray surrender and maintaining parity, madam.
What is this? It seems to be a standard thing, sir.
Correct, ma'am.
What is this?
379, madam, not named in affair. Only allegation is confession of co-accused. And nothing is seized from me, my lord. The lordship call for the
I
record.
think when you don't succeed in anticipatory bail, you come through.
No, I am not filing anticipatory bail in this case, madam.
No, that's what. I think the choice is this, either this or that.
No, I am not filing anticipatory bail.
Another form of,
only
another form.
5,000 rupees and one hammer, my lord.
What?
And already recovered from the co-accused. And I am the not named in implication on the basis of the confession of co-accused only.
Right.
That is the reason I pray surrender and parity kindly maintain, my lord.
I'm not inclined of the surrender that.
I have also annexed, my lord, annexed 2, page 11.
There's no IA also in this, sir. Nothing.
And principal, that principal accused already released on bail.
Yes.
That is my submission, my lord.
Yes.
I surrender and move for bail. Lordship consider direct to surrender and move for bail. I am not filing anticipatory bail, my lord, in this case.
There's no date also given, sir, for surrender. What's the kind of order is this? You may not surrender for the next 2 years, for all we know.
No, this is a fresh case, my lord.
No. I tell you, I permit you to surrender and apply for bail. You don't surrender for the next 2 years. What happens?
Police is searching for me.
That's what. So with this order, you'll be moving around.
No.
Yes.
No, I will surrender. You will
say that till I'm surrender, till
I submit, my lord.
permitted to surrender. Until I surrender, you can't touch me.
I pray, my lord. You will also have to within 2 weeks. I will surrender. The question of taking the order, I will moving doesn't rise.
Sorry, sir.
Beyond 2 weeks. What I submit, your lordship granted 2 weeks time. I will surrender within that stipulated period, my lord.
The prayer is for quashing. I'm not prepared to quash right now. That's the end of the matter. Yes. We go by the prayer. You go by the prayer you made in your application. That's it.
I have also annexed the bail order of the another co-accused from whom the material has been seized, my lord. Page 11, my lord. Lordship kindly see.
That's all right, sir. Don't mix up. Bail is separate. Whenever you apply,
I am not asking for granted bail directly. I surrender the court will consider, my lord.
You're not even surrendered. You'll have to apply for bail.
Within 2 weeks, I am bound to surrender, my lord. If you lordship direct, I am bound to surrender.
Sorry, sir.
And I am not asking that directly that court below should be granted bail to me. He will consider according to the law and on merit.
We go by the prayer in your 482. You ask for quashing. I'm not inclined to do that at this stage. As simple as that.
Permitted to surrender, my lord, at least.
No. Set out the paragraph. First prayer paragraph. You say at this stage, the court is not inclined to grant the relief as prayed for. The petition is dismissed. Right.
Oblige.
Yeah,
mention item 12. Item 12 may kindly be adjourned, my lord. In any another court, I will engage, my lord. So for item 12 is concerned, that maybe another date they kindly be fixed, my lord.
No, I'll come back after lunch, sir.
Item 33 permitted to withdraw.
Because in other court, I will engage, my lord.
We'll call it out. There's one item 13, somebody was there, no?
21 kindly, my lord, next week, my lord. Item 21.
1 minute, sir.
Item 29 and 35 want to withdraw.
1 minute, sir.
Yes.
Somebody was there in 13. What happened to him? Some 13 or something. No, from Puri. I think he was appearing from Puri. Which item did he mention?
Item
12 non-obvious. What item did he mention?
One capital on there, Mr. Das. Item 47. Defect is defectively employed.
No, this person was... I think 12. I think 12, nobody's there. July for the last stage.
Item
you mentioned.
Item 21, my lord.
1 minute.
Kindly taken up, or my lord, kindly next week.
Why, sir?
Kindly taken up, my lord, or I am not present before your lordship.
You are now present, sir. Kindly argue.
Yes, my lord. Person filed this case, quashing the order of cogniance, my lord. Ground is my lord. Opposite partner 2 is the wife. Filed 2 cases. First, this is the second case, my lord. On same occurrence and allegation also. In both cases, 498A and 4 of DP Act, along with other offences. Annexer 2 is the first case. Annexer 2 is the 1cc case. Thereafter, filed the present FIR, my lord.
All right. What happened in that 1cc case?
In both cases, cognizance already taken, my lord.
So what? Nothing. What is going to turn on it? Nothing, sir. Same thing.
Kindly tag both cases.
Tagging, that district judge can do tagging, sir. Why should I do a tagging here? CRPC, you people know the provisions much better than I do, sir.
On same 498 case separate.
You say permitting the petitioner to raise, put the prayer clause, and then say permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed. All right.
Item 29 and 35 on the withdraw, my lord.
All right. 29?
35.
29 and 35?
Yes, my lord.
Put prayer clauses both.
Pardon, my lord, item 22.
Petitioner seeks to withdraw the present petition, dismisses withdraw.
Item 22, my lord. I was not there. Our name transfer brief, my lord. Our name was not reflected, my lord. Taken over next week, my lord.
No, argued, sir.
File is not with me, my lord. File.
You can't appear before a High Court without file, sir. Very wrong. Then let the order remain.
My lord, transfer brief, my lord. I have entered appearance to.
I'm prepared to hear you. Take out your paper book, argue. Yes. Can't come to a High Court without brief, sir. Very bad idea. All right.
There may clear item 47. Item 47. Item 47. On where Mr. Das is out of station.
Let it be called out, sir. Let it be called out. Yes.
Item number 34. So item number 34, please. Item 34.
None of this dismissed.
Item number 36.
You'll have to put the
May I please,
clause and say none of this dismissed. I don't know. All right. All right.
May I please, on behalf of Mr. P.R. Singh, may I be permitted to submit your
Yes, yes.
My lord, the petitioner has challenged the order of rejection of the 311 petition, your lordship.
No, 35 called out. 35 withdrawn. Withdrawn. All right. Yes.
My lord, the trial court has rejected my 311 petition on the ground that the High Court has only permitted, while setting aside the conviction order, the SATA said that, okay, only the permitted the trial to the retrial by the Court of Additional Session Judge. Retrial would be taken from the stage of defense. My lord, there are certain prosecution witness I want to examine, for which I have moved an application for under section 311. So my lord, they may permit me to, because of the High Court's order, the trial court didn't allow me to.
No, the line here used is retrial would be taken up from the stage of defense.
Defense, your lordship, but there are certain witnesses, your prosecution witnesses, because I have to examine. So therefore, I have moved an application for this.
Then you have to
my lord,
challenge the order of the division bench.
My lord, the language of 311 is very clear, your lordship. If a just trial of the, it is been moved for the essential for the just decision of the.
When were these examined? When were these PWs examined?
My lord, the liberty may be given so that I can approach that. Liberty may be given. If it is necessary, then I will move the trial court for the.
No. What are you challenging here?
I am challenging my 311 petition has been rejected.
Yes.
Solely on the ground that the High Court has given only allow me to the retrial to be started from the stage of defense.
Correct. He's absolutely
on that ground.
Correct.
But there are certain witnesses, vital witnesses, which I want to cross-examine those witnesses, your lordship. Therefore, I moved an application before the trial court. So trial court rejected only on this ground because they are tied, because the High Court has already given a restriction that okay, the trial has to be retrial has to be commenced from the defense stage.
Correct.
That is the reason that for which they have.
It's a correct order.
My lord, only be permitted, so the liberty may be given because there are certain witnesses which have to be
not possible. Not possible.
The 300 is very wider, your lordship. Your lordship, that just essential for the just decision of the case, your lordship.
Correct. It's a challenge in the present petition is to an order dated 13 March 2023, passed by the learned Additional Sessions Judge Sundargarh in ST case number 62/60 of 2013, rejecting the prayer of the petitioner accused for summoning all the prosecution witnesses on the ground that they could not be properly cross-examined by the defense lawyer. Paragraph. The background is that by a judgment dated 16th August 2019, the division bench of this court, while disposing of criminal appeal number 255 of 2017, ordered a retrial after setting aside the conviction and sentence of the petitioner and remitted to the case to the Court of the Additional Sessions Judge Sundargarh, observing open petition, but the retrial would be taken up from the stage of defense. First of unquote. It transpires that thereafter, on 25th October 2021, that is nearly 2 years thereafter, on 25th October 2021, the petitioner accused filed a petition to call 3 witnesses on his behalf, that is defense witnesses. And this application was allowed on 27th October 2021. Stop. In spite of repeated summons, the said witness DWs did not appear. And on 2nd November 2022, NBW was issued against the said DWs, which were yet to be executed. Paragraph. It is only thereafter that the application was filed by the petitioner accused under section 311 CRPC for summoning of the PWs for further cross-examination. The trial court has correctly noted that the said PWs were examined many years ago. That is, even prior to the trial court judgment dated 29th March 2017, convicting the petitioner, which judgment was reversed by this court while remitting the matter to the trial court for commencing the proceedings at the stage of defense evidence. From the stage of defense evidence. Full stop. Further, as correctly noted by the trial court, the direction of this court being very specific that the retrial should commence from the stage of defense evidence. There was no occasion for the trial court to permit the petitioner to again summon the PWs for further cross-examination. Full stop. It is apparent that the said prayer would indefinitely delay the trial, conclusion of the trial, and defeat the very purpose for which the matter has been remitted to the trial court by this court. The court is unable to find any error having been committed by the learned trial court in passing the impugn order dated 13th March 2023. The petition is accordingly dismissed.
Well, only 3 witnesses because there is the informant who himself stated in his one statement, your lordship, that he was in custody. So that is the reason that I want to cross-examine the informant, your lordship. Which is after, if I'll cross-examine the prosecution witness 3 witnesses, your lordship, I may not need to cross-examine that defense witness may not be required also.
Item 37.
May it be results. An identical matter. Lordship, remember that Provident Fund matter.
Right.
Yeah, I'm giving the order of passed by your Lordship. There your Lordship has directed following P. Mohanlal's case and other cases. Lordship have said that I should file affidavit. Here, my lords, the unit who was the unit who was supposed to deduct through me, my lords, now I have been the only implemented in the FIR. Now I am being prosecuted under the Provident Fund Act. Now an FIR was lost. Lordship will kindly see Annexer 6 series. The learned magistrate at page 241, without taking cognizance and without recording his satisfaction that a prima facie case is made out, has issued summon. 241, Lordship may kindly see. That is JMFC Bodville in GR case number 191 of 2015. Same offense. 2000 for non-deducting the depositing the employees' provident fund from 2011
this passed almost 3 years ago, sir.
Yes, 3 years ago, my lords. My lords, that is correct, my lords. But your lordship will kindly see. This is a matter, my lords. As your lordship have in 2018, I have filed those applications as still pending before this honorable court, my lords.
Which applications?
My lords, these other criminal miscases, my lord, under 482. That is, my lords, I'm giving other copies also, and your lordship directed the matters to be listed on 17th of April, my lords.
These are all connected. The stream italics.
Yes.
Correct. List along with criminal MC 2057 of 2018 before the roster bench on 17th April. All right.
My lords, here, my lords, only I require there is an interim application, my lords.
That's all right.
Interim application. No, my lords, what has happened, my lords? Yes. Your lordship will kindly see. Here, my lords, I'll take more lordship only 2 minutes. I'll not take more than 2 minutes. The lordship, what the magistrate writes, the record is received today from CSI, that is Court Sub-Inspector Bodville. The record is for the appearance of the accused persons, Mahesh Kumar Agarwala, hence issue summon to him.
But that date is long cross, sir. That's a date of some November 2020.
November 2020, my lords.
Today we are in April 23. Nothing
that is correct, my lords. But lordship will see the position of law, my lords. I need not submit, my lords. Lordship have seen Pepsi Foods followed in Sunil Bharti Mittal's case, that it should not be, someone should not be issued in a routine manner.
Nothing is happening. Obviously,
my lords.
It's anyway, they come up on 17th. All right.
Lordship is posting it to
17th April, along with that.
17th?
April.
17th
No,
April
which
is
is that
gone,
date?
my lords.
Which is this? When is this coming up?
Lordship may fix any date.
No. This must have. This
is already in the list of
so
port number 5.
List along with. That's all. Before the roster bench. All right.
My lords.
I don't know when. No date has been given in that.
The
17th
date has
April,
been
it would have
given
come in the.
one of the cases, date has been given.
Ah,
The
so
8
which is that
matters, my lords. And your lordship have extended. Those matters were listed in February to the
No. They'd asked this to be listed in the roster bench on 17th April. What happened?
My lords, it is in the list of the roster bench.
All right. So
and
along with. All right.
Item 38.
None appears dismissed.
Item number 39.
VC. Item 38, I'm in the VC, your lordship.
Tell us. Yes.
My lord, this is a petition under section 482 of CRPC to quash the entire proceeding, your lordship. On the ground that, my lord, I have been implicated in this case basing on the confessional statement of the co-accused, who was the driver of a truck, highway truck, in which it is alleged that some sand was transported.
Yes.
And the driver could not produce any legal document for the said transaction, for which he was apprehended and case was initiated against him, your lordship.
Yeah.
But I am being the owner of the said vehicle.
Yes.
My lord, have been entangled in this case, my lord.
Yes.
My lord, my contention is that, my lord, they are offense under section 379 of the IPC and 21 of the MMDR Act and 52 of the Minor Mineral Concession Rules 2016, your lordship.
Yes.
379, there is, for all these offenses, there is no direct allegation against me. If at all,
it is your truck which is transporting the sand. That's more than enough.
My lord, the only thing is that your lordship may kindly consider there is neither 120B or neither 108 of IPC, your lordship.
Where's the need for all that, sir?
My lord, because there is nothing, there is no seizure, nothing.
This is your truck, sir. You are the owner of the truck. You don't even deny that you are the owner of the truck.
But there has to be some allegation, your lordship.
What more, sir? That will all get established after investigation.
But that 161 statement at least has to be revealed some iota of
No, nothing at all. Nothing. 161 is not the
contention. My lord, the second round of contention that I would like to place before your lordship. Your lordship, MMDR Act section 22.
Yes.
Specifically speaks that that cognizance of an offense has to be taken by a person authorized.
Only FIR has been registered, sir. Now that stage has not even reached.
My lord, the FIR has been lodged by police, your lordship.
Yes.
And has to be by a person authorized on this behalf, my lord.
All right. All this you can take at the appropriate stage. This is not the stage for all this. What do you wish to do, sir? All right.
To withdraw, my lord.
All right. Put down the prayer clause. Consider the petition after arguing for some time. Seeks leave to withdraw the present petition. Dismiss this withdraw.
Obliged, man.
Item number 39.
None appears dismissed.
Item number 40.
Now 40 was permitted to withdraw, my lord.
Dismiss this withdraw.
Item number 41.
May I please, Lord, sir. But in this case, my lord, the petitioner challenged the order dated 17th of October 2009, by virtue of which the learned court below dropped the execution proceeding of the petitioners without realization of the maintenance amount, my lord, from the opposite party husband, my lord. My lord, the learned court below, my lord, Judge Family Court, in the order dated, my lord, 19th of July 2012, directed the opposite party.
This is coming up after notice, right? Notice already petition on 14 December.
Notice already issued, your lord.
So has notice been served?
Well, as per noting in the cause list, addressee avoid to take notice.
Unserved notice returned with the endorsement, addressee not claimed, avoid to take delivery. I see.
Avoid.
All right. There is a noting by the registry that open quotation, addressee not claimed, oblique, avoid to take delivery, unquote. The respondent is accordingly presumed to have been served. The opposite party, sorry. Paragraph. The grievance of the present petition is that the family court Jajpur has closed criminal P execution case number 90 of 2017 filed by the present petitioner, oblique wife, seeking recovery of the maintenance amount awarded to her. Under section 125 bracket 3 CRPC. Without insisting on the recovery of the arrears of maintenance of rupees 44,000, even while sentencing him to 1 month's imprisonment. One month's simple imprisonment. But there is an order at 1710, subsequent order has been passed?
Yes, Your Lordship. By virtue of that order, my lord, the execution petition has been dropped by the Learned Court.
Right. It is further pointed out that by the subsequent order dated 1710-2019, while directing the Managing Director, Odisha State Poultry Products Cooperative Marketing Federation Limited, Bhubaneswar, to recover the aforementioned sum from the respondent husband, who is supposed to be having an OPOLOFED sales booth. The entire proceedings has been closed. Paragraph. It is obvious that in execution proceedings, unless the entire amount is recovered, the proceedings cannot be closed. Paragraph. In that view of the matter, the order dated 1710-2019, to the extent that the proceedings, execution proceedings have been dropped, is hereby set aside. And the said CRP EXE 90 of 2017 is restored to the file of the JFMC.
My lord, Judge Family Court Jajpur.
Judge Family Court Jajpur, to be continued till the recovery of the entire amount. The petition is disposed of in the above terms. A copy of this order be sent to the court of the family judge, Jajpur, forthwith.
Obliged, deeply obliged.
Item 42.
None appears dismissed.
Item number 43.
Same order.
44.
There was a direction on 20th March 2020 for issue of notice. Immediately after the state went on shutdown in view of the COVID pandemic. Thereafter, I have filed a requisition on 25th May. But instead of issuing notice, noting it that delay in filing of requisite.
Anyway, what's the matter about?
Miller, notice not sent. Though there is
What is the order dated 14/11/2017? What is this? Cognizance, taking cognizance?
No, Millard, here the order was maintenance order passed under Domestic Violence Act, but the opposite party number 2 has filed execution case under 128 of CRPC. My humble submission is that when there is a provision for enforcement order under Domestic Violence Act, filing a petition under 128 CRPC is not maintainable.
This one,
Accepting that,
NBW, there's an NBW issued against you.
yes, Miller.
Was that stayed by this court?
Yes, NBW has been stayed
When?
on 20th March 2020.
Now we fix a date, you appear, and till then the stay will cut.
Miller,
We fix a date, you appear on that date.
Miller, my humble submission is that when there is a provision under
All that is over. You have enjoyed the liberty for how many? 3 years now. One day you have to appear in that court. How long can you avoid? Someday you have to appear, sir. 3 years you've enjoyed the stay. Now time to appear.
But proceeding had to end.
All that fine. We'll have important questions of law decided, you appear in that court.
And I may be
You have enjoyed liberty for 3 years now. It's all right.
Liberty, I can't raise that question for the time.
No need. You appear now in that court. You say the petitioner will appear before the court of the... Which court is this? SDJM Khurda in criminal case number 79 of 2017 on 9th May at 11 a.m. Till then, the NBW and DW issued against the petitioner will not be executed. It is made clear that this protection is only till that date. After appearing in the court, it will be open to in the court concerned, it will be open to the petitioner to seek other appropriate reliefs in accordance with law. The petition is disposed of. The interim order is vacated.
Item number 45.
None appeals dismissed.
Item number 46.
None appeals dismissed.
Item 47.
Same order.
Well, item 47, Miller.
Yes.
On behalf of Mr. Das, Miller, Lordship called this matter 1 week after. But in the meantime, we will remove the defect.
No. It's a 3-year-old matter, sir. Where's the question of now taking more time for defect?
Out of station.
No, it's all right. It's all right. It's all right, sir. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed. Yes.
Item 48.
None appeals dismissed.
Item number 49.
Same order.
Item 50.
Item 50, liberty may be granted to raise all the pleas.
Permitting the petitioner.
Item 51.
None appeals dismissed.
Item number 52.
Same order.
53.
May I please? My lord, in this case, the present petitioner pray for the quashing of the affair corresponding to city case number 7 of 20, arising the Laika PS case number 27 on dated 11 to 2020. Now pending before the Lawrence Session Judge Judge Jharsuguda, my lord. And the case is allegation is, my lord, the present petitioner lodged the affair. Your lordship kindly peruse the annexure running page 15, my lord. The undated 11 to 2020 time 17 hour 0.1, my lord. Affair number 26, my lord. The present petitioner is a advocate, my lord, is a member in the Odisha High Court Bar Association, my lord. The allegation is, my lord, the affair is advocate being lodged the latent report, effect that the one Jharsuguda, the village of so-and-so has been allotted the house under the government scheme on the request of I am looking after the construction and also invest the money of for the expense of my family member has been working in home in 20 years till today. In order to verify the progress of the work on dated 9 to 2020 about 6 p.m. I want the count of completion of...
Sir, this is a SC/ST Act, no point.
My lord, point is, my lord, the allegation,
yes.
Your lordship kindly pay the second affair, my lord.
Yes.
I have already elaborated in affair say that as per the affair, the house of the informant is not a public place, my lord.
All right.
He stated that
all that can't be examined at this stage. Yes.
My lord.
It can't be examined at this stage. Yes.
Sir, till today, no charge sheet has been filed, my lord.
Because of
intentionally, one advocate, my lord,
yes.
harassed by the public, my lord.
Right.
Your lordship kindly pay all. I have mentioned all the things, my lord.
Yes.
In my ground, my lord.
Yes.
as per the FAR, house of the informant is not a public place. Who is the offense under Section 3 Act is not attracted in the case of the case, and definition of the 3(1) of the clearly speaks that intentionally insult or intimidate with the intention to humiliate the members of the scheduled caste and scheduled tribes on the place within the public view matter. As per the allegation, informant of the place occurrence in the house of the informant which is not in the public place, my lord.
Yes.
So the offense under Section 3 could not attracted in this case. So far, the being an advocate doing the public work, my lord, he intentionally do this, my lord. Till today, no charge sheet filed, my lord. Your lordship kindly consider this fact of this because he is doing all the public work of this, my lord. Intentionally that is done. The second affair also lodged thereafter. Your lordship kindly peruse the second affair that is lodged in same after 3 hours. That is affair number 27.
Yes.
And undated in same date, my lord.
Yes.
The offense under Section 3 couldn't attracted against the.
Yes. Anyway, permitting the petitioner to raise all pleas the appropriate stage. Right.
Item 54.
May I please? Pardon. The changed scenario as the trial has been progressed, may I pray your lordship to conclude the trial within a reasonable time?
It will be open to the petitioner to request the trial court to expedite the conclusion of the trial. No other directions are sought at this stage. Petition is disposed.
I pardon me, Lord. Item 47, I could not hear him, Lord. Item 47.
So we permitted you to raise all pleas at the appropriate stage. All right.
Item 55.
None appears dismissed.
Item 56.
56, my lord, liberty may given to raise the points before court below.
Permitting the petitioner to resolve this.
Item 57.
None appears dismissed.
Item number 58.
Permitted to withdraw, my lord.
Dismissed is withdrawn.
Item number 59.
59 may I please it. In that case, the case arising out of matrimonial dispute between the parties, the present petitioner and the opposite party number 2 as husband and wife. The case has been a DP proceeding has been initiated against the husband and now the matter has been amicably settled between the husband and wife. The present petitioner and the opposite party number 2.
Where is that?
Opposite party number 2 that has not I have not filed my adjournment. I'll file the compromise.
No, you point out the trial courts permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. Right.
Item number 60.
Obviously.
None appears dismissed.
Item 61.
Same order.
62.
Liberty may be given to raise all the disputes.
All right. Permitting the petitioner.
Item 63.
I may plead your lordship, but I'm on virtual mode.
Yes, please.
The petitioners are the bank managers, my lord. The complainant had taken loan of 6 crore somewhat. He was defaulter. Then, my lord, SURFACE Act came into force. And now he is claiming that he has lost financial losses, blah, blah, this, that, and losing the affair. And lordship can come to page 5. Page 5, paragraph 5. Very interestingly, even we were not there during the time these transactions were caused. The petitioners were not there.
Well, what has happened in the case? You have to find the status. You took an adjournment for finding out the status.
DRT case is pending against the complainant, and the SDGM matter is still steady because we are on bail and it is on. It's not no further proceeding has been initiated, but nothing has been happened.
But you have not made the informant a party, sir. The informant has not been made a party.
I'll make informant tomorrow.
All right. Mr. Mishra, the senior counsel states that he needs time to implead the informant as a party to the proceedings. That is requested for the roster bench on 22nd June.
All right.
Item 64.
None of is dismissed.
65.
None of is dismissed.
From 66.
None of is dismissed.
Item number 67.
My lord, it was dismissed for non-prosecution due to my hospitalization on
28/10/2022. I had undergone an operation, therefore I could not answer. Paragraph 2, I have taken that.
What's the main matter about?
Main matter, my lord. The petitioner was the executive officer of the Angol municipality, my lord. Informant is the niece of the petitioner, my lord. The allegation is that he is the maternal uncle. Allegation that father, mother, and maternal uncle, others, family members, they went to the in-laws house of the informant to try to forcibly take it. Took away from the in-laws house, my lord. So, Lord, kindly say, I was on training in Gopamanda Academy of Administration on the date of occurrence. 3 days training was there.
All that alibi plea and all can be gone into later.
My lord, officially I was in the training. That certificate I have given, my lord.
All this will trial court.
At the time of framing the charges, I used.
Yeah. You see, for the reason stated, the order is recalled and restored to file. In the main matter, you say, permitting the petitioner to raise all pleas at the appropriate stage. The petition is dismissed.
Framing of the charges.
Whichever stage, appropriate stage. Yes.
Item 68.
68, my lords, I paying for quashing of the entire criminal proceedings, my lords. In the meantime, my lords, my friend has appeared for the OP number 2. He has filed an affidavit which is at flag K.
All right. Counsel for OP number 2 confirms the affidavit filed by her, stating that all the disputes with the present petitioner have been settled. Accordingly, just take from the prayer clause and all proceedings consequent that take away quashed.
Item 69.
Lords, item 69 and 70. Lord, on behalf of Mr. Mahanti is admitted in the Tata Memorial Hospital, my lords, for throat in the cancer is operation, my lords. So 2 weeks after.
Counsel for the petitioner stated be unwell. Let's put for the roster bench on 5th July.
Great fellows. 70 also same.
All right.
Item 71.
Please, my lord. My lord, here, my lord, the wife is the informant. She is also the petitioner, because basing on the complaint filed by the wife, there is a proceeding initiated against the husband and in-laws. That outside the court there was a compromise, and there also now the matter also settled. Now the wife is also residing in her in-laws house. So the complainant, the present petitioner, wants to withdraw this complaint case.
All right. You're the state counsel has to verify this, no?
Yes.
You want to verify it? Counsel for the state wants time to take instructions, since the petitioner is the informant who is seeking quashing of the proceedings. At his request, list on. Ask the IAC or somebody to.
Yes, madam, the wife herself also.
That's why, sir. That's
sir. Let's sort that maybe.
Yeah. This is for the bench on 16th May.
All right.
Item 72.
My lord, in this case, my lord, the matter amicable settle in between party, my lord, and the opposite party number 2 also filed the affidavit on that basis, my lord.
I'm for the informant.
All right. Counsel for the informant confirms that the parties have settled the disputes and that affidavits have been filed by OP numbers . And it confirms the affidavits filed by the parties. To that effect. In that view of the matter, take from the prayer clause and all proceedings consequent that way can be quashed.
My lord, both applications.
Right.
And another one is CLMC number 1809. My lord. My lord, may I permitted to one thing, my lord, name of the court. My lord,
name of the court.
My lord, by mistake, my lord, that is SDGM Khurda instead of JMFC Cognizance Khurda.
So what is the correct?
My lord, JMFC Cognizance Court Khurda. That is the correct.
Pending the code of the JMFC Cognizance Code Khurda. All right.
Item number 73.
You'll have to correct the prayer clause, sir. The prayer clause be corrected by the counsel of the petition accordingly. Right.
Item 73.
None appears dismissed.
Item 74.
My lord, I am on the VC. My lord, I am on VC.
Yes.
My lord, this is a case where I have filed this case before the lordship, rejecting my 205 petition by the learned trial court under the PMLA Act. In the meantime, on the last date on 17th of April 2023, the learned court below has issued an NBW against me, for which I may be permitted to file a IA.
No, you are. I'll give you a date, sir. You appear on that date. That's all.
Sir,
Which is this court?
it is the PMLA court, special court PMLA comes CBI court number 1, Bhubaneswar.
The petitioner will appear.
My lord, I may
in
be
the court of the special judge, learned ADJ comes special judge CBI court number 1, special court bracket PMLA.
My lord, I may be permitted to.
No. In CMC bracket PMLA case number 47 of 2017 on 10th May 2023.
Because he's a cardiac patient, my lord. That is the reason I have annexed all the documents.
So which is why you're getting 20 days time, sir.
My lord, he's a cardiac patient. He's getting treatment out of the state, my lord. He's from Delhi. Out of the state.
That's right. He can fly down, sir. Bhubaneswar to Delhi, there are lots of flights.
My lord, I will be permitted to withdraw.
Then you put down the prayer clause, consider the petition after arguing for some time, seeks leave to withdraw the present petition, dismisses withdraw.
Item 75.
So, may I please lordship? But the petitioner is praying for quashing the entire proceeding. By OneSys case number 6 of 2016, which is pending before the JMFC Patrapur Ganjam, in the ground that the petitioner was lodged an FIR before the concerned PS on 25/7/2014. Subsequently, the accused person, or the opposite party number 2, filed OneSys case after 2 years. That is OneSys case.
But you are coming to this court after 7 years.
My lord?
You are coming to this court after 7 years, sir.
Yes, my lord. That is the reason. That is the reason.
What is the reason?
That is the reason. Kindly have a glance. Annexer 3, page 18, my lord.
Yes.
Kindly have a glance.
Yes.
Page 3, page 8, annexer 3. Order sheet that is 23/7/2021.
Yes.
No further order has been received from the Honorable High
Asian
Court of
resurfacing.
Orissa.
Correct. Asian resurfacing.
That is, my lord?
Asian resurfacing judgment has been applied, sir. That's why. Anyway, if you haven't understood, it's okay. All right.
My lord, according to that order, the Asian Refreshing Road Agency Private Limited versus CBI, appeal number 1375 of 1376 of 2013, the Supreme Court of India, para 35, it has mentioned that in all pendency cases where stayed against the proceeding of a civil criminal trial is operating, the same will come to an end and expire of 6 months of the from unless in the annex in the appendicial case by the staying order of stay. I explained that thereafter the proceeding was initiated and no further proceeding was concluded, as because the High Court also stayed the matter, and also the OneSys case also. They kindly have a glance page 19 up to last 23, page 23, my lord. All the dates are they are absent. No proceeding has been conducted, and no initiation has been concluded, and even if the OneSys the GR case also, they have also not operating for the future proceeding.
All right.
So that
it's all right. Permitting the petitioner to raise all pleas with the appropriate petition is disposed of. Yes.
Item 76.
We're permitting you to raise all pleas at the appropriate stage. That's all. Yes.
I please your lordship, appearing from virtual High Court Balasur.
Yes.
My lord, the CRLMC petition challenging NBW order dated 26/6/2019.
Yes.
My lord, while returning from a place, 15-20 youths obstructed the way of the victim and they fled the spot. That is the prosecution case. My lord, these petitioners were never extradited. They have been living in their locality since last 3-4 years, and there was an issue against them.
We'll give you a date, you appear on that date, till then the NPW will not be executed. That's it. You say petitioners will appear before the court of the SDJM Baleshwar in CT case number 7 of 2019 relating to Chandipur PS case number 1 of 2019. Will appear in the court of the JMFC bracket city, you see, in that case on 10th May 2023 at 11 a.m. Till then, the NBW issued against the petitioners will not be executed. However, the stay will, this interim order is only till that date. Thereafter, it will be open to the petitioners to seek appropriate reliefs in accordance with law.
My lord, the rest of the accused have been released on bail.
That you apply to that court, sir. Yes.
Item 77.
Item 70, may I plead your worship? Here, the petitioners, initially they have been implicated in a case trial by magistrate as well as 3 of SC/ST Act, your lordship. During course of investigation, they have been allowed to go under 41A, your lordship. After conclusion of investigation, the charge sheet was filed and pursuant to charge sheet, cognizance was taken and summons was issued, your lordship. My only apprehension, your lordship, is the SC/ST Act is there. If pursuant to summon, if I will appear before the court, your lordship, I will be taken into custody because of 15A of the Act, your lordship. Here, your lordship, I am relying upon a judgment of apex court, your lordship. Here, lordship, the para 10 is very clear, your lordship.
Yes.
More importantly, the appellants apprehends arrest not at the behest of the CBI, but at the behest of the trial court. This is for the reason that in some parts of the country, there seems to be a practice followed by courts to remand the accused to custody the moment they appear in response to the summoning order. The correctness of such practice has to be tested in an appropriate case. Suffice to the presence to notice that it is not the CBI which is seeking their custody, but the appellants apprehended that they may be remanded to custody by the trial court, and this is why they seek this protection. Here, in lordship, is because the summon was issued, your lordship, without noticing the informant, your lordship. So the trial court cannot.
That was not an SC/ST Act case, sir.
That is general. Your lordship.
Yes.
In a similar case, your lordship.
Yes.
The order passed by this honorable court. Here, this honorable court at para 3, your lordship, may peruse. Para 3 of the order, your lordship. Considering the above submission and the fact that the main accused has been released on bail and some of the co-accused persons have been released on police bail, and the decision of this court that Pramod Kumar Rai and other versus State of Orissa reported in such and such, is because this is a case, your lordship, where this honorable court has given some procedure how the SC/ST bail application has to be treated by the court below, your lordship. Unless this observation be made, we have some apprehension, we may be remanded to custody by the trial court. If pursuant to someone, we will appear before the court, your lordship.
But there they're not even named in the FIR, sir. Petitioners have not been named in the FIR.
But those who are not named, they have been implicated as accused during investigation in this case, your lordship, and 41 was, they were allowed to go on bail under 41, your lordship. In this case, I have been named and I was allowed to go on bail by 41A, your lordship. And the summon was issued in my favor, your lordship. Your lordship may peruse the summon that there the court below has specifically about at running page 30, your lordship, last paragraph. Accused, namely such and such, are on police bail in view of notice under section 41A of CRPC served. place the case record to the dealing clerk fixing on date 14 to 23 for issuance of summons to the above noted accused persons for their appearance put upon the date fixed. So it clearly shows that your lordship were on bail on 41A, your lordship. And your lordship, the apex court has held once on bail, it will continue till the end of the trial, your lordship. Admittedly, we are on 41A, your lordship. And because of the provision of 15A of SC/ST,
these petitioners have been specifically named in the FIR, madam.
That's
Yes.
what.
we are ready to appear before the court below yourself. Only the apprehension pursuant to summon, if you will appear, then we will maybe remand to custody. Already on bail, your lordship, during investigation.
That's the police bail, sir.
Yes, your lordship. But there is no allegation that either we have threatened the informant or we have misused the liberty granted to us during course of investigation, your lordship. There is no.
Then that court will consider all that, sir.
In view of your lordship.
You move for bail, they'll consider it according to law.
In view of Pramod Kumar Rai case, your lordship.
That you cite, whatever case you have to cite, you cite, sir.
Unless it been directed, your lordship, the court below will not take into consideration, your lordship. Pursuant to summon, if I will appear, your lordship, I will be remanded in custody, your lordship. And admittedly, we are in bail, we have never misutilized the liberty given to us, your lordship.
Right.
And it's a summon of 23, your lordship.
Anyway, actually, these kind of petitions, the prayer is only for quashing and nothing else. So I don't know why we're passing all these elaborate orders on bail and this and that.
Your lordship, we have filed a miscase, your lordship, interim application. Lordship may consider.
All right, you put down both the main petition and I8. Consider the petitioner does not want to press the main prayer for quashing of the GR case number 376 of 2022 pending in the court of the sessions judge, comes Special Judge Koraput Jaipur at this stage. The offences under which the petitioners are being prosecuted are take from para 1 of the IA. Consider the petitioner states that the petitioners will appear in the trial court on 11th May 2023 and file an application for being enlarged on bail upon in the event they are apprehended, in the event that they are remanded to custody upon their appearance. Full stop. In such event, it will be open to in such event, the court concerned will consider such application on bail for bail in accordance with law. Keeping view the decision in Pramod Kumar Rai versus State of Orissa on 1767 OCR 309. The petition is disposed of about.
78.
None appears dismissed.
79.
On behalf of Mr. P.K. Behera, praying for 1 week after, madam.
All right.
Oh, bless me.
Why is he asking for adjournment?
He's suffering from viral fever, madam.
All right. Counsel for the petitioner stated to be unwell.
Okay.
List on 10th May for the roster petition.
Item number 80. Item 80.
None appears dismissed.
81.
May I please just here the questioning of a criminal proceeding, my lord, on the ground of compromise, my lord, that the matter has been compromised between the parties during the pendency of the case, my lord, my informant is appearing, my lord, OP number 2.
SC/ST, how can be compromised, sir? SC/ST Act, how can there be compromise?
My lord, 80. 89.
81.
How can there be compromise? SC/ST Act can't be compromised.
The compoundable offense, my lord.
SC/ST Act, sir.
My lord.
Ah. Yes.
Compoundable in nature.
You're completely mistaken, sir. Totally mistaken. What do you wish to do? Give it back. How are you also filing an affidavit like this? Please understand the law, sir. You're all people who are supposed to be lawyers of some years of standing. You say permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of.
Item 82.
Permit to withdraw.
And put down prayer clause and says, after arguing for some time, seeks leave to withdraw the present petition. Dismisses withdrawal.
Item 82.
82 may please. Lordship, in 82, there is a defect notification to file a certified copy of the rejection order. My lord, kindly allow some times to file the certified copy.
Recall PW1 for further cross-examination.
Yes, my lord. My 311 petition was rejected by the London trial court.
Let's see that. What's the offense under, sir?
My lord, it's offense of 376(2) and my lord.
So you want to call the prosecutrix?
Yes, my lord.
When was she examined? 3921.
My lord, it's technically added 376(2) and my lord, it's a fixed case of 376, my lord, only. As for FIR story, it's a 376 case, but technically added 376(2) and my lord.
So we know what happens. You wait for 1 year, then recall the victim. We all know this. This has to stop. 376 case, all this has to stop. You see, the petitioner is facing trial for the offences under section 347, 376(2)(n), 506 IPC. The victim, PW1, was examined and cross-examined at length way back on 30th September 2021. After waiting for more than a year, on 23rd February 2023, the petitioner files an application under section 311 CRPC for her recall. Full stop. The trial court has rejected the application by the impugned order dated 6/3/2023. Having heard learned counsel for the petitioner, the court is satisfied that no error has been committed by the trial court in rejecting the petitioner's request, given the nature of the case and the witness sought to be recalled, who is a victim of rape. The court finds no ground made out for interference. The petition is dismissed.
Item 83.
Yes, my lord.
83,
Item 80, my lord.
Come. Tell us.
80.
80.
Earlier,
what is your petition number? CRLMC number.
1826, my lord. Early execution order dated, my lord, 12/2/18, page 14, my lord. And order dated 7/2/20.
And order dated?
Order dated
7 to 20, page 15.
Oh, I see. This is 125 CRPC proceeding.
My lord.
You're for the wife.
Yes, ma'am.
All right. It is pointed out by counsel for the petitioner that despite orders having been issued by the trial by the JMFC Dhamnagar in execution miss case number 67 of 2017 on 12/2/2018 and 7/2/2020, no steps are being taken for executing the NBW and DW issued against the respondent, who's avoiding compliance with the maintenance order. Notice, counsel to the state accepts notice on behalf of 1, 2, and 3. Notice to respond before, returnable before the roster bench on 16th May 2023. In the meanwhile, the SHO, which is the police station, sir? IIC, okay. The IIC Dhusuri police station,
yes,
will file a report in this court,
yes,
on the status of execution of the NBWs issued in the DV miss case number 83 of 2016. Correct, sir?
Yes.
DV miss case. It's DV miss case.
Yes, DV miss case.
DV miss case number 83 of 2016. All right. All right.
DV miss case.
83.
Case number 67 by 2017. Page 14.
Execution miss case 67 of 2017. Right. All right. Execution miss case. Right.
Yes, ma'am.
Item number 83.
Yeah, my lord, petitioner is preferring this application for quashing of FIR and entire criminal proceeding, which was initiated by the wife of opposite party number 2 against the petitioner, my lord. And in the meantime, the
compromise.
Yes, my lord, matter has been compromised, and wife has filed a divorce petition before the family court Bhubaneswar. And during the pendency of the divorce petition, both filed a compromise petition for compromise, and they want to separate each.
Where is the affidavit, sir?
That
you have to produce the affidavit. You say counsel the petitioner seeks time to produce the affidavit.
Annexure 2, my lord. That is the.
That's only the petition, sir.
Yes.
Where is the order on the basis of that petition?
Yes, my lord.
That's not there.
No, my lord. That. Like notice may be issued, my lord, to the opposite
notice
party.
He accepts notice for it. It is claimed that there is a compromise between the petitioner and respondent, opposite party number 2. You say notice, he accepts notice for 1. Notice to opposite party number 2 returnable before the roster bench on 26th June. What?
Filed a IA for a stay of further proceeding, my lord.
What is going to happen in the proceeding, sir? She's asset is compromised. She's not going to do anything. Or just notice on the AE. Right.
Item number 84.
Prior to this incident, there was a compromise in between the husband of the petitioner, informant, along with the petitioner in the police station, that nobody will create any disturbances. In the meantime, the petitioner constructed the building, but the informant, along with some persons, they came to the spot and demanded money, for which the petitioner filed the FIR against them. And
now he is filed against you.
9 days
Yours
after.
is 40 of 2023, his is 45 of 2023. Within a few hours or what? Same day or same day is filed it or waited for 2 days?
Not in same day. After 9 days, she lost the FIR against the petitioner.
All right. Yes, sir.
And I want to cause this FIR.
You've not even made him a party, sir. You've not even made him a party.
Sorry, for that.
What? You want to withdraw, you withdraw.
No, I may permitted to make the party.
No. What do you wish to do, sir? We permit you to take all pleas at the appropriate stage. That's the best. Permitting the petitioner to raise all pleas at the appropriate stage.
But we will give in to make her the party,
Oh, it's all right.
with better petition.
No, it's all right. Yes.
Item 85.
May I please, Your Lordship? But in a criminal proceeding, the informant filed a petition for inquiry in terms of section 340 read with section 195 of the CRPC in view of the fact that the statement of a witness, two statements of the same witness diametrically opposite to each other were filed in the proceeding for the court below. Now the land court below rejects it, saying that it will be dealt with during trial. And the issue is not with regard to whether he will be acquitted or convicted. The issue is with regard to if a evidence
Normally
is
it
laid.
awaits the conclusion of a trial, sir.
But Your Lordship will kindly see 340 says that if there is a pilot, the
I know,
material.
but it may say that, but ultimately you have to wait for the end of the trials. My witnesses are all so fickle. They can make three contradictory statements in the same
No,
time.
it has been produced by the police before the court below. So that is the difficulty, my lord.
All right. Not inclined at this stage, sir.
As Your Lordship pleases.
All right. The court is not inclined at this stage to interfere with the impugn order dated 20th March 2023, passed by the SDJM Baleshwar.
Relevant page is page 22, Your Lordship.
Right. Declining to entertain the petition filed under section 340 CRPC, read with section 195 CRPC during the pendency of the trial. The petition is accordingly dismissed.
Item 86.
May I please, Your Lordship? I am appearing through the virtual court Kalahandi.
Yes.
Your Lordship, this is the petition. This is a petition seeking for the cause of FIR by Twamul Rampur PS case number 25, dated 17 February 2023.
Yes.
Your Lordship, my allegation to which the opposite parties even agree that there is a civil suit pending before the Twamul Rampur Civil Judge Junior Division marked as Annexure 6, Your Lordship. It is against one B. Radhika.
Yes.
Your Lordship, B. Radhika is the person, after the order was passed against her, she has gathered some person, that is the opposite parties, and obtained the signature in a paper and have lost the FIR. And sir is appearing on behalf of the opposite parties. And today he has filed the Wakalatnama through the online mode, through computer online mode. And Your Lordship, the petitioners they belong to the other state, the Andhra Pradesh and Telangana. They are absolutely not known to the local language. So scolding the people here in a slangs or in their caste name is practically not possible. This entire incident is like V. Radhika is the kingpin of the entire.
Whom is your colleague appearing for? Opposite parties 2 to
13.
13. I see.
Yes.
All right. You say, what is his name, sir?
Pradeep Kumar Bihar, sir.
One Mr. Pradeep Kumar Bihar, advocate, appears on behalf of opposite parties 2 to 13 in the virtual court, stating that he has filed a wakalat in their behalf today in online mode. It is claimed by both counsel to the petitioners as well as Mr. Bihar that the parties have entered into a settlement.
Yes,
Your Lordship.
And seek time to place and record the relevant document.
Affidavit has already been filed, Your Lordship.
And that an affidavit to that effect has already been filed. The IIC of PS?
Your Lordship, Twamul Rampur PS.
T.H. Rampur
My lord, the
will
yes, Thuamula
Rampur.
Rampur will verify if the affidavit is a genuine one. List before the roster bench on
copy of the affidavit may be
10th
served.
May 2023. A copy of the said affidavit be served on counsel for the state as well as the IIC. T.H. Rampur forthwith. All right.
Your Lordship, I have also filed one IA in that effect to not to take any coercive step against me.
Till the next date, no coercive steps be taken against the petitioners. Just
Much
put this-
obliged, Your Lordship.
All right.
Item 87.
Your Lordship, I'm challenging the order of cognizance on the ground of compromise, Your Lordship.
On the ground of?
Compromise, Your Lordship.
You are appearing for OP number 2.
Yes, Your Lordship.
What are the offences?
Offense are 376, 506.
376 can't be compromised.
Your Lordship, in that case, I my alternative prayer, Your Lordship.
Yes.
Either NBW was issued against me.
Yes.
I will appear before the lower court. Lordship may only say that while considering my bail application, that will take into consideration that compromise was made.
No. That's a witness will have to get into the stand, sir, please. How can there be a compromise?
Both the father and victim and
You say counsel to the petitioner while not pressing for the relief of quashing at this stage reserves the right to raise all appropriate pleas at the appropriate stage in the trial court. The liberty is so granted. That's the only order prayed for, sir. That's the only order prayed for. The petition is disposed of in the above terms. Yes.
Item 88.
May I please, Your Honor? The petitioner challenged the order dated 13/2/2022 passed by JMFC for Kotak in 166 case number 311/2022. This is a case under section 138 of NI Act. And while taking cognizance by the court, has not considered the service of the notice not complied, the order that section 138 clause B and C, he has not complied because no notice has been served to me, served to the petitioner. And if Your Lordship can see the petition that you can on page 11 that the address is given, that the name of the accused in point number 2, the Vinay Kumar Parida, care of Karunakar Parida, Balikuda Gopalpur. No post is mentioned here. And
right.
district Dogasimpur. But
Anyway, you are
I am
here
the
now.
man of Kotak.
Yes.
I am man of Kotak.
You are here now, sir. Now you can appear in that court. Now that you know all this.
Now, I have not to get any notice.
Anyway, you have all the papers. Now you can appear. No, nobody stopping you.
That plea may kindly be taken on that court.
Permitting the petitioner to raise all pleas at the appropriate stage of the trial court. The petition is disposed of. Right.
Item 89. Your Lordship may take up 90 first. Both are interconnected.
All right. You're a doctor.
Doctor, my lord, the litigating matter has been settled in Supreme Court also with regards to quantum. My lord, page 13. And the lady is also employed, my lord. Page 13, order dated 3/2/2023. After taking 7 adjournments, the petitioner wife, my lord, the opposite party here, this is the order passed. 3/2/2023. The petitioner is present and PW1 and discharge. PW and P1 is marked. OP is found absent on repeated calls. I could not cross-examine her. And prior to that, if your lordship would be kind to turn to page 12, my lord would find, starting from 18/11/2022, 6/12/22, 21/12/22, 10/1/23, all these dates he has been taking time.
And on that day, I missed out because my lawyer could not reach there.
That's not true, sir. Just come to that page 14.
Page 14.
On
That is
petition-
the subsequent subject matter in the other case. And yes, when your lordship is there in 14, my lord may kindly look at from the bottom.
Yes.
Thereafter, those 7 numbers of adjournment were given, but cross-examination of PW1 could not be completed on 322. These adjournments were at the instance of the wife opposite party, your lordship, not at my instance. And interestingly, on that day, if your lordship is looking at the order dated 31/3/2023, she files a petition for adjournment. That is there annexed to the other petition, my lord. At page 22 of the first petition.
Yes.
That she won't be present on that.
125 proceedings pending since 2015.
It's a question of cross-examining her. It's not a question of debarring me from examining her or examining myself as well. By order dated 31/3, I have been debarred from examining myself.
How old is the son?
Son is about 10 years, my lord. Your lordship, kindly look at the order also passed by the Honorable Supreme Court.
Yes. What does she do?
She's a teacher, lecturer, my lord, college.
So this 125 is for the son?
Only for the son.
Fuck.
I'm not on that, my lord. It is a question how much I will pay. Your lordship will look at this. How it has been decided in the proceeding by the Honorable Supreme Court.
Yes.
And I am paying this money and also the educational expenses.
Yes. So what more do you want, sir?
I want to cross-examine her.
For what?
My lord, and examine myself. These are the two aspects.
Examining yourself, it's okay. What is this cross-exam? What is it going to lead to? You want to show that you don't want to pay even this one?
No. This I am, in any case, I am paying. Supreme Court is above everything, my lord.
Then?
In any case, I am paying this. But there's an opportunity and the manner in which the matter has proceeded. 7 dates she took adjournment. 1 date my lawyer was not present.
No, not in Clint. The challenge. What is the other petition about? Challenging the other order.
31/3. At least let me examine myself here also. The other one, that 31/3 application, that is the subject matter in 1894. Order dated 31/3/2023.
All right. Only for closure. That you want to.
Yes, my lord.
What happened on 12/4? You told them it's pending here.
12/4, it is pending here.
All right. You see, while in Criminal MC 1894 of 2022.
23,
sorry. The challenge by the petitioner, who's a practicing medical professional, is to an order dated 31/3/2023, passed by the Family Court Puri, declining the prayer of the petitioner to further recall and further cross-examine his wife, opposite party, number 1. In Criminal MC 1895 of 23, the challenge is to the same order to the extent it closes the petitioner's evidence on the ground that he had failed to file his affidavit of examination chief till then. Paragraph. It appears that the marriage between the petitioner and opposite party number 1 has run into rough weather. And in the civil proceedings, it has traveled up to the Supreme Court of India on the issue of payment of maintenance. We'll stop by the order dated 2nd August 2021 in civil appeal numbers 4553-54 of 2021. The Supreme Court passed an order directing that the petitioner would pay interim maintenance, monthly maintenance of 10,000 for the minor child who is presently living with his mother. Minor son who is presently living with his mother. Paragraph. The proceedings in which the impugn orders have been passed are also proceedings instituted way back in 2015. by the wife under section 125 CRPC seeking maintenance for the son. In these proceedings, it is in these proceedings that the petitioner is insisting on recalling her for further cross-examination. Full stop. Paragraph. A perusal of the impugned order shows that such a prayer was in fact allowed on 29th July 2022. But despite several adjournments thereafter, the PW1's cross-examination could not take place. Full stop. Although Mr. Sarangil and a senior counsel petitioner argues that these adjournments were at the instance of the wife, the perusal of the impugned order shows that steps were also not taken by the petitioner in that regard. Paragraph. Keeping in view the long duration of the proceedings, the court is not inclined to interfere with the impugned order dated 31st March 2023 to the extent it declines the petitioner's prayer for recall and further cross-examination of opposite party number one, wife. Paragraph. However, as regards the closure of the evidence of the petitioner, the court is of the view that subject to the petitioner paying costs of ₹10,000 to opposite party number one within a period of 2 weeks from today, and placing on record before the Family Court Puri in CP number 127 of 2015 proof of payment of such cost. One more charge should be given to the petitioner to file his affidavit of examination in chief on or before 15th May 2023. The case will now be listed before the Family Court Puri on 16th May 2023 for the petitioner to report compliance with the above directions, and for the Family Court to further proceed in the matter in accordance with.
Common order, your lordship, passed.
Yes. Copy the order be sent to the concerned court.
Item 91.
To interrupt your lordship, item number 87, your lordship, that your lordship does not incline as because 376 was there. NBW had issued, lordship may fix a date to surrender. Till then, I may be protected, your lordship.
No, sir, that's not even the prayer. There's no IA in that.
The IA is there, your lordship, to that
Where?
effect.
86?
87, your lordship.
87. Where is the IA? I didn't find it.
CRLMC 1886 of 2023.
All right. You say, then put down this IA number also in that. Then it say the petitioner will surrender before the ADJ comes special court under POXO Act Bhadrak in case number 104 of 2021 corresponding to TDPS case number 38 of 2021 on 12th May at 11 a.m. Till then, the NBW issued against him will not be executed. It is made clear that the stay will not continue thereafter. It will be open to the petitioner thereafter to seek appropriate reliefs in accordance with law.
Item 91.
May I please, on behalf of Mr. Ponda, may I permit? Challenging the order dated 27/6/2022, madam. For non-appearance of the petitioner, my lord, non-taking of steps by the advocates, my lord, the law and court below issued NBW, madam. It is a case of 2011, madam, and all the offences are bailable. For the last 10 years, the present petitioner facing the trial, madam. Lordship may direct, I will surrender, madam.
All right. Counsel, the petitioner states that the petitioner will surrender the court of the JMFC Lakhanpur in GR case number 943 of 2011 on 8 May at 11 a.m. till then, the NBW dated 5th July 2022 issued against petitioner will not be executed. It is made clear that stay will not continue thereafter.
May I pray, my lord, your lordship may direct the petitioner to release on previous bail.
No, it will be open to the petitioner to seek appropriate remedies thereafter for the grant.
Unless your lordship direct, he can't, my lord, since NBW.
All right, if the petitioner is taken into, is remanded to custody on his appearance and moves the application for bail, it will be considered in accordance with law on the very same day by the trial.
Since all bailable, man. Offense are bailable, man.
That's right. Okay, then what do you want, sir?
Then since NBW issue at the stage of accused statement for that. Obligement.
Yes.
Item 92.
92, my lord, register pointed out a defect for filing of certified copy of Annexure 1. April, lordship may grant me 2 weeks time, I will file the.
What's the matter about? Annexure 1 is what?
Annexure 1 is the complaint petition which the petition is praying for quashing of the criminal proceeding. Because your lordship may kindly see section 138 of the NI Act.
Yes.
138.
Yes. Yes.
138 proviso, man.
Yes. Yes, please.
Provided that nothing contained in this section shall apply unless. So it is mandatory. These three A, B, C have to comply. Now, my lord, we can see B.
Yes.
The payee or the holder in due course of the check, as the case may be, makes a demand for the payment of the said amount of money by giving a notice in writing to the drawer of the check within 30 days of the receipt of information by him from the bank regarding the return of the check as unpaid. So the word is within 30 days. So it cannot be extended to 31. Beyond 30 days, it can be extended. Now, my lord, can you see my list of dates? Page B.
Yes.
Serial 3, my lord, can you see? The first intimation regarding return of check is 21/3/2018. Then serial 4. 26/3/2018 is the date of intimation of the another check. Now you let's say serial 5. The notice was issued on 10/5/2018 beyond the 30 days. So the proceeding is not maintainable. And Honorable Apex Court has laid down the law. Which A, B, C.
What is the check amount?
20 lakhs.
10 lakhs, 10 lakhs.
Yes.
Or 2 checks.
Yes, 2 checks.
But you can file one petition for 2 checks, is it?
No, one complaint case has been filed.
Mr. Mudali states he relies on the judgment in Jugesh Sehgal versus Shamsher Singh Gogi.
Paragraph 13.
14 SCC 683 and urges that since the demand notice in the present case was issued in respect to the 2 checks in question beyond a period of 30 days after receipt of intimation by the complainant from the bank regarding dishonorable checks, the complaint itself was time barred and not maintainable. Notice returnable before the roster bench on 12 July.
I filed an IM.
Till the next date, no further proceedings shall take place in the
published
1cc case number 70 of 2018 pending the court of the SDJM Udala.
Published.
Item 93.
Here, please, your lordship. The petition challenging the order that 13/1/2023, my lord, as the Lord and Court below has taken cognizance in absence of ballasting report and sanction order, my lord. That in the said order, the learned magistrate had mentioned that punishment under Section 25 Arms Act is imprisoned for life, my lord.
The charge sheet has already been filed, sir.
My lord?
Charge sheet already filed.
Yes, charge sheet order. That about my lord, the life punishment is not in the simple 25 Arms Act. And on 1AA, there is a provision of life punishment, my lord.
Permitting the petitioner to resolve, please.
My lord, I also filed that the petitioner filed a bail application, my lord. As he is inside all the offencer tribal magistrate and languishing in jail custody since more than 7 months, my lord.
This is not the thing for bail in this 482, sir. You have to file a separate application for that. All right. Permitting the petitioner to raise all please the appropriate stage. The petition is disposed of. All right.
Item number 94.
Item 94, my lords. There, my lords, I filed a miscase to enclose that FIR copy. Also, Honorable Court directed to file, get that certified copy of the FIR. Also, with due humility, I tried, but in the meanwhile, my lords, the matter has been transferred to Jatni PS. Also, Jatni, Judicial Magistrate Jatni, my lords. It took some time, my lords. It will take some time to get that. But the case is like this, my lords. The son issued some check, it was degenerate. I'm the father. I'm residing at Balangir and the transactions is at Bhubaneswar. I'm ailing person, handicapped, confined in bed. 2 of my legs are not working because of suffering from constant arthritis. The humble contention, the FIR story does not make out a case at all against me, my lords, either under my lords 420 or under my lords 138 or under 506 or 294.
But you've not even made a complaint in the party, sir. You've not made the complaint in the party.
I have not made a complaint at the party, my lords, because that is what happened was this is arising out of a GR case. The he filed an FIR. FIR was registered and it was registered as a GR case.
Still, sir.
It's not arising out of complaint case.
No,
General, what my lords says.
Technical. All these 482 quashing, you make the complainant informant a party.
My lords, I'll make him part.
No. What is the matter about?
Matter, my lords, quashing of the cognizance, my lords.
No, charge sheet is already filed, sir.
Charge sheet filed. Thereafter, I have come, my lords.
Order for the charge at the statute stage, you can take all.
With the humility, my lord, charge also doesn't make out any case against me.
Already framed. Charge framed.
Charge framed doesn't make out any case.
All from the stages crossed.
That is what
trial must be going on, sir, now.
No, that is what, my lords, I humbly submit, I humbly appreciate for my lords, that the case against the father is not made out at all.
Right.
That is what my humble submission.
Then the trial will collapse in no time.
May I submit, my lords?
Yes.
This man is suffering. My lords, the fact remains 70 years old.
He's suffering because of this 482. The trial is not going on.
No, the trial is not going on. So far that son is concerned, I am not here, my lords. So far the father. So far father is concerned, 138 is not make out.
Right.
So far
you're on bail anyway. You're on bail.
No, I am on bail. I am on regular bail. I have not violated my. I am on bail. Only thing is that my last two whether 420 is not made out against me.
Not at
294, 506 and 507 whether made out or not. That is what my humble submission. 506, the allegation is that over phone, the doctor and I threatening. My lords know that so far that 294
this case has progressed to the stage of framing of charges against the petitioner.
May be permitted to raise all that. May be permitted to raise that all that point to discharge.
Who's preventing you? But charge must have been framed quite some time ago.
The charge have been framed quite some time. That is all right. In the meanwhile, it has been transferred to Jatni JMFC. May I may be given that.
Counsel for the petition seeks leave to withdraw the present petition with liberty to urge all the pleas available to the petitioner in accordance with law at the appropriate stage in the trial. At the appropriate stage, you see. Full stop. This post of is withdrawn with liberty is prayed for. All right.
Item 95.
Interim order is vacated.
Item 95. I am filing one affidavit. There are maintenance matter. I am the petitioner, the husband of petitioner opposite party number 1 and father of opposite party number 2 and 3, my lord. In the meantime, both of them major and the daughter is staying with me since last 5 years. And I have, my lord, spent all the money for her high studies. Son is also coming and taking money, my lord, from me. He is not staying with her mother. Here, my lord, the law and court below allowed maintenance, my lord, 4,000 to the mother and 105,000 to the both son and daughter. They are at that time minor, my lord. Thereafter, 125 No, I've sought the copy today, my lord. To my learned friend, my lord, appearing for the wife.
I'm appearing for it.
All right.
My lord.
Counsel appearing for the petitioner has tendered an affidavit stating that the daughter is residing with him and that he's paying 5,500 per month to the opposite parties by deduction from his salary. He's also bearing the expenses for the higher studies of the daughter. The son has also become a major, as has the daughter. Full stop. The above affidavit is not disputed by counsel.
No, I am disputing.
All right.
I have to file counter appeal because as per my instruction, the daughter is residing at Berhampur and son is residing with me. Son has not yet become major as per the cost title. And he is saying that son has become major. And now we are on a criminal miss.
The daughter is now staying, my lord, at Hyderabad.
These facts are to be considered in a proceeding under section 127. If he is saying that daughter is residing with him and he is paying, who debarred him to file application under 127 CRPC?
All right, then you just take this all back. You file this in the court registry. You've got a copy of this?
Yes,
ma'am.
just
all right, you just keep that affidavit part. Then you say the affidavit is taken in record. Counsel for the petitioner, how opposite parties, how disputes the above affidavit and states that the government's in the above affidavit and states that he will like to file a response thereto. This be done before the next date, released before the roster bench on 19 July.
My
lord. Item number 96.
96, my lord, I am appearing for the wife opposite party, my lord.
This
is a proceeding under the DV Act. They are challenging the order of execution, my lord.
But nobody is appearing for the petitioner.
A maintenance order have been confirmed by this honorable court in a criminal division.
Anyway, your task is easy today. None appears for the petitioner. Dismiss for non-prosecution. All right.
The interim order may kindly be vacated, my lord.
Yeah, obviously. Interim order vacated.
Item 97.
Yes.
Also, item 97, liberty may be granted to raise all the pleas.
All right. Liberty to raise all pleas at the appropriate stage.
Item number 98.
None appears dismissed.
Item number 99.
None appears dismissed.
Item number 100.
You're an all-rounder.
Well, that opportunity I got from the Lordship. But here, what has happened? It's arising out of a complaint case.
Yes.
Under the.
So, Mr. Otta is appearing in the virtual court.
Yes.
Right.
Yes.
Right.
But here it is under 138 NA Act.
Yes.
Lord, here I have not issued the check to the opposite party. Here, Lord, I have, after receipt of demand notice, I replied to the complainant stating that the check has been issued to some other person and he has misutilized and he has stolen from check leaf, the entire check leaf, one check leaf he has stolen and that he has handed over to the complainant. Here, Lord, I am a ops of licensee. Lord, I have given the check to the sub-inspector excise that to hand over that checkbook in my shop. What he has done, he out of the entire leaf signed checks, one leaf he has taken out and stolen. That for that, Lord, I have lodged also FIR. FIR also, I went to the SP also. They didn't take any action. I have filed also complaint petition before that same court where the cognizance has been taken by the JMFC Lord Chandikol. But that also is pending before the court. But with regard to Lord check, I have not issued. So Lord 138 doesn't attract. It says, Lord, Lordship kind of glance to 138.
No, your signature is there on the check.
Yes.
They stolen the check.
Yes, but I have not handed over to that check to the complainant because it says, Lord, to another person.
That is a matter of evidence, sir. Whether you handed it over to him or not is a matter of evidence. That's a matter of evidence.
No, that is disputed because
obviously,
yes, obviously. What he has done, the complainant has not filed my reply before the court below. And also the court below what has done, it has been filed after 30 days. It has been condoned without notice to me also. No, that the 142B also debars. Section 142B says within 30 days is to file. He has not filed within 30 days and it has been condoned by the magistrate.
Let's see that order 11/12/2018.
Annexure 5, my lord. That page, my lord. 24, my lord. When counsel for the complainant is present and files court fees, heard the on delay condoned petition under section 142 NA Act, put up letter for order on the point of cognizance, and letter order is also same day, 11/12. The record is posted for orders on the point of cognizance. Peruse the original documents, court fee, affidavit on the materials available record. I find prima facie 138 NA
Sir,
Act.
this delay condoned, Mr. Ota. That order dated 11/12/2018. That was passed in the absence of the accused.
No notice.
That should have been done only after notice to him, sir.
That should have been.
So we'll send it back for that stage.
Yes.
All right. You see, it is seen that the order passed by the JMFC Chandigarh in 1cc number 277 of 2018 under section 138 of the NI Act, filed by the respondent, the opposite party, was in the absence of the notice to the petitioner accused. So, stop by the said order, the delay in filing the complaint under section 138 NI Act has been condoned in terms of the proviso to section 142(1) of the NI Act. Paragraph. The court is of the view that as far as condoning the delay in filing the petition is concerned, since it goes to the root of the matter, notice ought to have been issued to the accused persons before passing an order thereon. On that short ground, the order dated 11/12/2018 condoning the delay and taking cognizance of the offence under section 138 of the NI Act against the petitioner is hereby set aside. 1cc case number 277 of 2018 will now be listed before the JMFC Chandigarh on 15th May 2023 to be proceeded with afresh from the stage of considering the application of section 142 NI Act. So on the above date, the petitioner will
But
remain
also
present.
there is a subsequent order also.
Petitioner and the complainant will remain present.
No, there is a subsequent order, Annexure 9. They have filed application for interim compensation. And that also, the magistrate also has passed order in spite of my objection that it is.
See, all in view of the above orders, all subsequent orders passed by the learned JMFC.
Under Annexure 9.
Bracket Annexure 9.
23/1/2020.
Including the order dated 23/1/2020 bracket Annexure 9.
Yes.
Does not survive.
No.
And are hereby set aside.
Obliged.
Pardon to mention, my lord. So for item 12 is concerned, my lord, this list, my lord, may kindly be adjourned because I am engaged in other court.
We have adjourned it. 4 July.
Pardon to, I'm really sorry that I was not appear at that point of time in item 24, my lord. Kindly allow for withdraw.
Withdrawing, is it?
Yes, my lord.
All right. Dismissed as withdrawn. 24.
Obliged, my lord.
All right. We put the prayer here.